Committee on Oversight and Government Reform will come to order. Without objection, the Chair is authorized to declare a recess at any time. We thank the panel and those in the audience for joining us. This is day 2 of a criminal justice reform oversight hearing. We've had 2 panels yesterday and a distinguished panel today, and we appreciate the time and attention. This is ripe for oversight, but it's even more ripe in time to do something about it. This committee is the Oversight and Government Reform Committee. There are a number of things we can do on a bipartisan basis to make this part of our society and this part of government working better. Today we continue our discussion on criminal justice reform, and the committee is devoting, as I said, 2 days on this topic for a very important reason. The time to enact meaningful criminal justice reform is now. At a time when gridlock has become the norm, something important happened yesterday. We saw 2 senators, 2 House members, and 2 governors on both sides of the aisle, in a bipartisan, bicameral way, express the need and desire to actually move meaningful criminal justice reform. While the details of the proposals varied, the unifying theme we heard was that reform is needed and there is no time to waste. States are leading the way in innovative reforms of which the Federal Government can learn. We were fortunate yesterday to hear from the Governors Bentley and Markell about the reform efforts underway in Alabama and Delaware. And they're not the only states. States like Texas and Georgia and others are making meaningful reforms and have led the way and shown that it can be done and reduce the rate of recidivism. As we continue our discussion today, it's time to continue to roll up our sleeves. We have the chance to hear from a panel of experts who can answer our questions about effective criminal justice reforms. And we're looking forward to hearing about specific topics: the use of evidence-based risk assessment tools to identify lower-risk inmates, identifying programs that have demonstrated record of reducing recidivism rates for use inside of prison facilities, keeping more juveniles out of prison, and what's going to happen to these people when they come out of prison. Remember, the vastly expanded number of Federal criminal laws and the use of Federal criminal courts in enforcing economic and other regulations is something that needs to be addressed. We also need to address the ever-increasing Federal prison population and the Bureau of Prisons budget. It's 140% of capacity. It's consuming nearly 1/3 of the Department of Justice budget. You can't continue to sustain those numbers. We need to also examine reforms that are smart on crime, but also protect public safety. There are people that have committed heinous crimes. They need to pay a punishment. They need to pay back a debt to society. But let's also remember that more than 95% of the people who go to prison, they're coming back out. Are they going to be better criminals? Or are we actually going to engage in the reform necessary to be the Department of Corrections? In fact, the bill that Hakeem Jeffries and I have sponsored would rename the Federal Bureau of Prisons to the Department of Corrections. That's the way it is in all 50 states. All 50 states, it's the Department of Corrections. But the Federal Government attitude and approaches this is it calls it the Bureau of Prisons. It's time to change the name, change the attitude and the approach, and recognize that we need to engage in reform. The prisoners are reentering the community, and too many are returning to a life of crime. When we look at a smarter, fair, and more cost-effective way for our criminal justice system to work, we must also ensure that our efforts do not jeopardize public safety. Indeed, some of the proposals discussed yesterday strike this proper balance. For example, we heard ideas from Senator Cornyn, Governor Markell, and others about using risk assessments to identify low-risk prisoners. Those prisoners can then be subject to community-based supervision instead of the expensive and counterproductive imprisonment. Or maybe it's some combination in between. The panel today has this type of expertise, and they've seen this up close and personal, and that's why this is an important hearing today. We look forward to exploring those ideas so we continue to find areas of reform that we agree on while standing firm on the policies and strategies that are essential to success. We again thank the panel. I'll now recognize the ranking member, the gentleman from Maryland, Mr. Cummings, for 5 minutes.
Chairman Chaffetz, I want to thank you again, as well as all the other members of our committee, for the very productive discussion we're having on how to make significant bipartisan, bicameral, lasting improvements to our criminal justice system. I also thank my esteemed colleagues who testified with us yesterday with such great passion and eloquence. Criminal justice is personal to me. I have seen the problems that plague the system through many lenses. As a young boy, growing up in the poorest section of Baltimore, watching my classmates go and be carted away to juvenile detention centers, I've seen it through that lens. I've seen it during my days as a young lawyer, representing criminal defendants who so often simply were minding their business when a police officer came upon them, said something, or in some instances told them to drop their pants in front of the girlfriends. It then escalated, and the next thing you know, he's charged with resisting arrest, assault on a police officer, disorderly conduct, and then he has a record. I've seen him as a state representative who has deep respect for the dedicated police officers that serve our community. I've seen them as a congressman representing a district where finding balance between law and order and crime and punishment is a profound concern to my constituents. And this year, I've seen them as a citizen of my community, Baltimore, a city where I was born, a city where I raised my family, a city where I've lived my whole life, and I watched it erupt after the tragic death of Freddie Gray. Unfortunately, one lens that has not changed enough is the lens of color. I can continue to see African Americans in this country facing daunting economic challenges, disproportionately high rates of poverty, and severe unemployment. There are too many communities of color that are missing family members, especially fathers, sons, and brothers who were in jail. African Americans are incarcerated at nearly 6 times the rate of whites. When these men leave prison, they come home to the same communities where they struggled to begin with. And so often there's nothing there for them. You see, they have been saddled with a record which bar them from getting grants to go to school, bar them from getting certain jobs. In some states, you can't even become a barber once you get a record. And at the same time, we tell them, go out there and do well, support your family, and there's nowhere to go. It is not unusual when I go back to my district, which is located not too far from the stadiums, for me to hear young men, I hear this almost every week, somebody comes up to me and says, Mr. Cummings, can you help me find a job? I don't want to do a crime, I just want to do a job. And then they tell me they can't get a job because no one will employ them. And so when they come back from prison or they have a record, they have a big mark on their back. It's very easy for us to say it doesn't matter. It does matter, because there are thousands upon thousands upon thousands of them, and the number grows every single day. In some cases, they lose their driver's licenses. They are ineligible for occupational licenses, and they have great difficulty finding any kind of employment. When they can't find a job, many return to what they know. They commit more crimes. And the cycle starts over and over again. A lot of people don't understand the criminal situation, and I kind of got a good view of it one time not long ago when a young man was talking about how he had, in my neighborhood, had now turned his life around and that he was now on the straight and narrow. And he said, I used to have to rob folk. And as I began to talk to him more and more, I realized that robbery was the way he earned his money. And it's not just one robbery. That's how he had to go out day after day after day, just like we go to work. That means that there are more victims and more problems. Yesterday, Senator Booker spoke about the 2.7 million children who have incarcerated parents and the 1 in 9 African-American children who have parents behind bars. These kids are more likely to be suspended from school and go to prison themselves. This is how the cycle continues to the next generation. As I mentioned yesterday, my oldest brother has been a public defender for 40 years, and he is now seeing families with 3 generations in the criminal justice system: grandfathers, sons, and grandsons all together. Ladies and gentlemen, this is the United States of America. We must do better, and we can. We cannot stand by while these alarming disparities and destructive cycles persist generation after generation. We owe to generations yet unborn to make lasting changes that provide opportunities and hope. We need to invest in reform now so the next generation can escape this cycle of despair. As I said yesterday, these hearings are a landmark moment for this committee. And Mr. Chairman, I applaud you for what you have done, and I applaud your staff for what they have done in working with mine. I really appreciate it. We have heard about groundbreaking legislative proposals like the Evidence-Based Bipartisan Safe Justice Act. We have learned how states are, quote, banning the box, and how private sector companies like Walmart and Coke Industries are changing their approaches so those with criminal records are not automatically disqualified from all employment. And that leads me to another point. It's not just government that has to try to make some changes. Corporations can play a major, major role, and we can help them and encourage them to do so. Governor Bentley talked yesterday about the importance of providing top-notch pre-kindergarten education for all children in Alabama. Governor Markell talked about women's prison in Delaware that hosted a culinary festival featuring the work of inmates alongside established professional chefs. These advancements are happening because we are coming to understand that we cannot look at our criminal justice system in a vacuum. We need to take a comprehensive approach to criminal justice reform. As I close, we have a unique moment, a bipartisan momentum for true reform, and it is ours to seize. But momentum is nothing without action. I hope that the hearings inspire strong action. My Republican colleagues and I disagree about many things, but on this issue, we have an opportunity to reach not only common ground, but higher ground. I want to thank the Chairman again for holding these hearings, and I look forward to hearing from all of our esteemed witnesses, and I thank the witnesses for being here. And with that, Mr. Chairman, I yield back, and I thank you.
I thank the gentleman. The passion and the belief in his heart on this topic is exuded every time, and I do appreciate working with you on this. I also don't normally do this, but I do appreciate the audience being here. This is a demonstrably younger demographic than we normally have in our hearings, and it's good to see. We don't have nearly enough young people involved and engaged in civics and in their government, and on this topic, we need your help, and so we appreciate your joining us here today as well. I will hold the record open for 5 legislative days for any member who would like to submit a written statement, but we'd now like to recognize our panel of witnesses. We're pleased to welcome Mr. Kevin Ring, Director of Strategic Initiatives with Families Against Mandatory Minimums. We have Mr. Mark Levin, Director of the Right on Crime and Center for Effective Justice at the Texas Public Policy Foundation. Mr. John Malcolm, Director of the Edwin Meese III Center for Legal and Judicial Studies at the Heritage Foundation. Ms. Liz Ryan, President and CEO of the Youth First Initiative. and Mr. Brett Tolman, co-chair of the White Collar Criminal Defense and Corporate Compliance Practice Group at Ray Quinney and Nebaker. I would also note that Mr. Tolman is from Utah, served as a U.S. attorney in Utah, was deeply involved with Senator Hatch and the Senate Judiciary Committee, and I have leaned on him heavily for perspective and insight on this topic, and we appreciate his presence and expertise here as well. Pursuant to committee rules, witnesses are to be sworn before they testify, so if you will please each rise and raise your right hands. Do you solemnly swear or affirm that the testimony you're about to give will be the truth, the whole truth, and nothing but the truth? Thank you. Please be seated and let the record reflect that all the witnesses answered in the affirmative. In order to allow time for discussion, you're going to see that members are coming in and out. We have several hearings going on simultaneously. We would appreciate if you would limit your verbal comments to 5 minutes. You will see a red light appear. That's your cue that you have gone over time. As my colleague Trey Gowdy likes to see, when you see the yellow light, that means speed up, as it does at every stoplight we see in this country. And by the time you get to red, you better be stopped. So, but your entire written record will be submitted into the record. We'll now recognize Mr. Ring. You're now recognized for 5 minutes. You push that button and make sure that microphone's close, and time is yours.
Can you hear me? Chairman Chaffetz, Ranking Member Cummings, members of the committee, my name is Kevin Ring. I serve as Director of Strategic Initiatives for Families Against Mandatory Minimums. Thank you for the opportunity to testify. I should mention you said there was a young crowd here. The youngest is my daughter, who joins us today. My older daughter is sleeping off the Taylor Swift concert from last night, so she couldn't make it.
Your testimony thus far is entirely truthful, I can tell you that.
Given some unique experiences, I've had a lot of time over the past 20 years to think about the federal criminal justice system, and I've been able to examine it from wildly different perspectives. In the 1990s, I worked on Capitol Hill as a staffer, both in the House and the Senate. I was a counsel on the Senate Judiciary Committee and helped draft some anti-crime legislation, really bad anti-crime legislation I see now. I then observed the legislative process from a different perspective, as a lobbyist. Ultimately, my work as a lobbyist brought me under federal scrutiny. After 2 trials and appeals, I was sentenced to serve 20 months in federal prison. I spent 15.5 months at the federal camp in Cumberland, Maryland. I then served 2 months of home confinement wearing a GPS monitor, which ended just a few weeks ago. I began working for FAM before I was indicted. I continued to work there during my trials and returned as soon as I got home from prison. I hope to talk about FAM's strong support for sentencing reform, especially the Sensenbrenner-Scott Safe Justice Act. But first, I wanted to share a few observations from my time in prison. I begin with the necessary caveat that I served in only one of the BOP's 122 institutions. But I think my observations go beyond there. First, I saw little to no rehabilitation in prison. There were few useful programs. The institution was either understaffed or uninterested in providing worthwhile programming. Drug treatment, trade apprenticeships, GED classes, I was a dog handler. There were few exceptions. Most people worked menial jobs and collected their 12 to 15 cent per hour wages. If you were not in the residential drug abuse program called RDAP, you were mostly limited to what were called ACE classes, Adult Continuing Education. These were taught by other inmates. Offerings at Cumberland included such life-enhancing classes as movie review, Jeopardy, and current events. Most inmates skipped these classes, but would sign the attendance sheet so the administration thought they went. The classes were 1 hour each week for 10 weeks, and then when you completed a 10-week session, you got a certificate. Prison officials seemed to know that these classes were worthless, but I think it was thought that if we went to them, we'd look busy and they'd look better for keeping us busy. The most glaring deficiency in the area of programming was the lack of any cognitive behavioral therapy or anger management counseling. I know some people still hold on to the myth that criminals, drug and white collar, are rational actors who review the U.S. Code and weigh the costs and benefits before breaking the law. The fact, however, is that the overwhelming majority of the inmates are not just poorly educated, but also have terrible social skills and very little impulse control, ability to delay gratification, or risk awareness. The result is bad decision-making. These, it seemed to me, were the shortcomings that needed to be addressed. At Cumberland, however, we had 250 inmates and 1 psychologist. And despite studies from the National Institute of Justice showing the effectiveness of cognitive therapy, BOP's main program for this is offered in just 2 of its 122 institutions. There are a few other things that are worth mentioning from my time in no particular order. The health care is miserable. The waiting list to have a cavity filled is 2 years. If you experience intense enough pain, they'll pull your tooth. One of my bunkmates, a successful businessman, had 8 teeth pulled during his 10-year sentence. Another fellow inmate was given the wrong blood pressure medicine and spent the night on the floor of the TV room after fainting. I spent 40 consecutive hours in solitary confinement because the administration decided to quarantine us when a scabies outbreak occurred. Without a book or piece of paper or pencil to write anything, I thought I was going to lose my mind. I understand now why so many people believe isolation is a dangerous and overused tool. I saw over and over how difficult it is for a family to survive the incarceration of one of its members. Finally, I witnessed how flagrantly the BOP is disregarding the Second Chance Act, which was passed by Congress in 2007. Low-risk, nonviolent inmates are supposed to be able to get up to 12 months of halfway house time. This provision was designed to save taxpayers' money and incentivize good behavior. It's not happening. The BOP says the problem is a lack of halfway house beds around the country. The GAO looked at the issue and agreed, concluding that Congress would need to spend more than $500 million more every year just to implement the Second Chance Act's halfway house provisions. Given this reality, I think members should rethink the value of legislative proposals to make inmates eligible for more of something they already can't get. My time in prison reaffirmed my belief that the only way Congress can improve public safety while reducing costs is to reform federal sentencing laws, especially mandatory minimum sentences. Mind you, I did not get a mandatory minimum sentence. You can't simply try to unclog the drain by giving some people a few days off here and there for good behavior and rehabilitation. You need to adjust the spigot and manage the inflow. The Safe Justice Act, just introduced by Representative Sensenbrenner and Bobby Scott, is a good example of legislation that would reduce the flow of inmates in a responsible way. I served with some prisoners who received mandatory minimum sentences that did not seem disproportionate. I met several others, however, who were serving mandatories that far exceeded any notion of a fair sentence. That is the problem with one-size-fits-all sentences. Not everyone is the same, and not every crime is the same. Mr. Chairman, one reason I think that lengthy sentences can be so counterproductive is because prison infantilizes people. You often hear that it hardens people, but I saw it infantilize people. I rarely hear people talk about this. Everything we do and everything we need as prisoners is on campus. Inmates have very few responsibilities. Within a couple of years, people start to become institutionalized. They know what it takes to get by day to day in prison, but lose touch with what it takes to live outside. So while some people absolutely deserve prison time, our goal should be to give them as little as is necessary to accomplish the purposes of sentencing. If society can get its pound of flesh with a 3- or 5-year sentence, go with that instead of 10 years. It's incredibly important to keep in mind that while people are in prison, the world does not stop. Technology advances, job markets change, children age and stop seeing their incarcerated loved ones as an authority figure, and spouses and partners bear burdens alone and often move on. And while all this is happening, whatever skills a prisoner brought to prison start to atrophy, and they don't gain any new skills. So we must be mindful that more than 90% of prisoners are coming home someday, and we want them to be successful, if not for their sake, for the sake of those who want to live in safe communities with less crime. In conclusion, we at FAM appreciate the leadership that you, Mr. Chairman, and Ranking Member Cummings have demonstrated in calling for these 2 days of hearings. We will continue to help in any way we can to make sure that all this momentum does not go to waste, and that we end this process with a meaningful reform bill that takes effect as soon as possible. Thank you.
Thank you. Mr. Levin, you're now recognized for 5 minutes. Did I pronounce it properly? Is it Levin? Yes.
Chairman, thank you very much. It's a pleasure.
It's your microphone. Make sure that button's pushed. There you go. Thank you.
It's a pleasure to be here. I started working on criminal justice reform with the Texas Public Policy Foundation in 2005, and then we launched Right on Crime in 2010, our national initiative with signatories to our statement of principles like Newt Gingrich, J.C. Watts, Grover Norquist, and of course our Governor Rick Perry, former governor. And we have a phrase in Texas, it ain't bragging if it's true. And since we began our efforts in 2005, our crime rate's down 24% and our incarceration rate is down 12%. But I'll tell you, even more than that, we're seeing that across the country. Over the last several years, according according to the Pew Center, states that have reduced incarceration have actually had a larger crime rate decline than the rest of the country. And we've seen major reforms in states such as Utah this year, congratulations, Chairman, but also South Carolina, North Carolina, Georgia, Mississippi, Kansas, Connecticut, the list goes on. And so this provides a lot of momentum, I think, for federal action as well. And we've seen reform in a host of areas in states, from mandatory minimums to earned time to addressing the growth of regulatory crimes. In Texas, we adopted the rule of lenity this year, which says if an offense is ambiguous, the benefit of the doubt goes to the defendant. We've also seen states like Mississippi, Maine, and Colorado safely reduce solitary confinement by more than 2/3. So let me talk a little bit about what federal reforms can take place. And we very much urge Congress to take action this year on comprehensive reforms, including both front-end and back-end changes. And the SAFE Act is excellent. There's also many other bills, your bill, Chairman Chaffetz, as well as some legislation that a working group in the Senate is putting together that will also contain front- and back-end reforms. So one of the places to start, of course, is sentencing, as Mr. Ring mentioned, and looking at the federal mandatory minimums. Once again, particularly as we look at nonviolent offenses, some of these mandatory minimums result in excessive prison terms that go beyond the nature of the offense. And so drugs is one of those examples. And so, for example, the problem with many of these mandatory minimums is rather than just focusing on kingpins, and we wish one more of those was in prison today in Mexico, but they focus on small-level drug dealers, low-level drug and even drug users. And so, for example, one of the problems is 21 U.S.C. 851, and what that says is if a federal defendant is convicted of as little as 10 grams of certain drugs and has one or more prior convictions for drug offenses, the mandatory minimum is 20 years with a maximum of life in prison. And if there were 2 prior felony drug offenses that the prosecutor files notice of, life without parole, life in federal prison is mandatory. And these prior offenses could even be state offenses that resulted in diversion, possession of very small amounts of drugs. So this is a major problem. And so to illustrate my point, we do have a safety valve now, but currently that applies to only 24% of all drug federal mandatory minimum cases. And it applies to only 24% of cases, even though only 7% who are charged with these federal drug mandatory minimums are considered leaders, supervisors, or managers. Now, in addition to drug cases, there are other problems with mandatory minimums. One of those deals with people with a felony record who have a gun or even ammunition, and these can result in mandatory minimums of 10 to 40 years. There was one particular case of an elderly gentleman in Tennessee who was hunting turkey with a rifle, and he wound up getting a 15-year mandatory minimum that a federal judge said was way too harsh. Now, turning to the back end, we also see a need for earned time provisions. Wisconsin implemented earned time several years ago, and they found that those inmates who took advantage of that and completed programs had a 17% recidivism rate compared to 28% of those who didn't, of similar inmates. We need to reduce the more than 12,000 in federal solitary confinement through disciplinary alternatives such as withholding privileges, a gradual process for earning your way out of solitary, and of course stop it releasing inmates directly from solitary confinement. Also looking at a bill we passed just this year in Texas, non-disclosure, where you can have your record sealed after a number of years of living safely in the community, crime-free, and be able to move on in your life. And then also we need to address the problem of over-criminalization and over-federalization. And this includes reducing the over 4,500 federal statutory offenses, which can be done through a military-based style closure commission, consolidating all remaining offenses in a unified criminal code. We also need to remove authority from federal agencies to impose criminal penalties by rule that are not directly authorized by Congress. We need to adopt a default mens rea provision, as Ohio did last year, so conduct must be knowing or intentional if not otherwise specified. And we need the Department of Justice to adopt guidelines to focus on federal prosecutions on those areas where the federal government has a clear advantage, such as those implicating homeland security, international relations, and crossing state lines. Finally, let me urge you to address the civil asset forfeiture problem. This has resulted in confiscation of money and property from many innocent Americans. And the FAIR Act is a great way to start that takes a number of reforms, including including making sure there's clear and convincing evidence, not just preponderance of the evidence, getting rid of equitable sharing, which states have used to circumvent some of their own restrictions on asset forfeiture, and also making sure the property is automatically returned to people if they're not convicted, rather than putting the burden on them to hire a lawyer and file a lawsuit. So I'll conclude by just saying we are so grateful to the bipartisan leadership that we are seeing on this committee and across Congress, and we're very encouraged that major reform can happen this year. Thank you.
Thank you. Mr. Malcolm, you're now recognized for 5 minutes.
Chairman Chaffetz, Ranking Member Cummings, distinguished members of Congress. As you heard, I'm the director of the Meese Center for Legal and Judicial Studies at the Heritage Foundation, although my remarks today, the views that I express are my own. I also spent a good deal of my career as a federal prosecutor and a criminal defense attorney. Sentencing reform, which will be the focus of my remarks today, is a very difficult issue. Some believe that too much discretion has been removed from judges and that increased incarceration has led to inequities in our society. Others believe that harsh sentences have taken some very dangerous people off of the streets, and that if such sentences are cut, crime rates may well increase. I understand why people of goodwill disagree passionately about this issue. When crime rates soared in the 1960s and 1970s, the idea of putting more people in prison for longer periods of time made a lot of sense, and to some extent, it worked. Crime rates leveled off, and since the 1990s have dropped precipitously. While there are places in this country where crime rates remain staggeringly and persistently high, we are, for the most part, much safer. Increased incarceration, especially of violent offenders, certainly deserves some of the credit, but how much credit is a matter of debate. While some experts estimate that increased incarceration may be responsible for as much as 35% of the reduction in violent crime, this means that other factors would be responsible for the remaining 65% or more of that reduction. Moreover, incarceration, while necessary, is a very expensive option. Indeed, the costs of incarceration have risen steadily over the past 15 years, but perhaps of even greater importance. Increased incarceration also comes with a human cost. There are now over 2 million adults behind bars in this country, which impacts not only the offender's prospects, but also that of their family members. Parents who commit crimes may not be the best role models, but they are breadwinners and are usually better than having no role model at all. Many studies indicate that children with incarcerated parents struggle and often end up turning to crime themselves. Today, the Bureau of Prisons constitutes 26% of DOJ's budget. It's projected to grow. That is up from 18% in 2000. This means less money for investigators, prosecutors, victim services, grants to state and local law enforcement authorities, and other priorities. Given this reality, I see each prison cell as very valuable real estate that ought to be occupied by those who pose the greatest threat to public safety. Now, nobody disputes that there are some people who should go to prison and never return to society. Most inmates, however, do not fall into that category, and approximately 95% of them will, in fact, eventually return to our communities. Congress is currently considering a number of front-end proposals which would reduce the amount of time that certain offenders are sentenced to. Most of these proposals focus on drug offenders and involve reducing mandatory minimum sentences. Now, let me be clear that I believe drug dealing poses a threat to public safety. The potential for violence, gang involvement, and lethal overdose is inherent in most drug transactions. Nonetheless, while drug dealers ought to be punished, I believe the pendulum has swung too far. Too many low-level offenders are being locked up for 5, 10, and 20 years when lesser sentences would suffice. Front-end reforms could involve reducing the length of mandatory minimum sentences for most drug offenders, expanding the number of low-level offenders who qualify for the safety valve, or some combination thereof. Congress is also considering back-end reform proposals, which would enable an offender either to get time off of his or her sentence or a change in his or her conditions of confinement. I support these efforts, too. Such proposals involve 3 things. First, expanding prison programs likely to reduce the risk of recidivism, such as educational, job skills, mental health, and substance abuse program. Second, encouraging inmates to avail themselves of such programs. And third, along with using needs and risk assessment tools, matching inmates with programs based on their needs and providing incentives for inmates to complete such programs. This type of reform is important because huge numbers of inmates have mental health problems, substance abuse issues, or both. Both conditions are associated with staggeringly high rates of recidivism, and prison programs addressing these conditions are sparse. Until that changes, prisons are likely to remain a revolving door. Many offenders, particularly those with only modest records who take advantage of such programs, could end up becoming productive, law-abiding members of society. So long as we are realistic and methodical in our approach, we should not give up on those whose lives can be salvaged. Now, in addition to sentencing proposals, Congress is considering important proposals related to overcriminalization, mens rea reform, civil asset forfeiture, collateral consequences, and juvenile justice, among others. These are all serious issues worthy of serious consideration, and I look forward to working with each of you on these and other proposals to reform our criminal justice system. I thank you for inviting me here today, and I look forward to answering any questions you might have.
Thank you. Ms. Ryan, you're now recognized for 5 minutes.
Thank you, Chairman Chaffetz and Ranking Member Cummings. My name is Liz Ryan, and I'm President and CEO of the Youth First Initiative. I'd like to start with a story. Khalif Browder, a 16-year-old boy, was arrested in 2010 and accused of stealing a backpack. He was automatically charged as an adult. He could not afford to pay the $3,000 bail, so he was held at the jail at Rikers Island. He was assigned a public defender, and because of backlogged courts, he was at Rikers for 3 years awaiting trial. He was beaten and starved by guards. For a year at Rikers, he was placed in solitary confinement. In 2013, the charges were dismissed. After he was released, he struggled to go to school. He took his life on June 6, 2015. Khalif Browder's tragic death underscores 3 of the most pressing issues we're facing in juvenile justice. First, the overuse of incarceration of youth. In the United States, on any given day, there are 80,000 youth in a detention or correctional facility. Like Khalif, most of these youth do not pose a serious threat to public safety, yet they are exposed to harm while incarcerated, such as physical abuse, sexual abuse, restraints, isolation, and solitary confinement. Khalif Browder's case underscores that youth in adult jails and prisons are especially at risk. Research shows that placing youth in correctional settings increases the likelihood that youth will reoffend. Yet, states and localities spend $6 billion a year to detain and incarcerate youth. By contrast, community-based alternatives to incarceration could more effectively serve youth and at substantially less cost. A second pressing issue is the prosecution of youth in adult criminal court. Khalif Browder was one of the estimated 250,000 young people who are processed in adult courts every year. Contrary to popular perception, the overwhelming majority of youth who enter adult criminal court, and even those who are ultimately convicted, are not there for serious violent crimes. For example, a Baltimore study showed that nearly 3/4 of the youth charged as adults were either transferred back to the juvenile system or had their cases dismissed. The research demonstrates unequivocally that trying and sentencing children in adult court decreases public safety. That is why the overwhelming consensus of justice system stakeholder organizations, as well as the U.S. Attorney General's Task Force on Children Exposed to Violence, recommend against prosecuting kids in adult court and against placing kids in adult jails and prisons. A third issue underscored in Khalif Browder's case is the pervasive unfairness, inequities, and racial and ethnic disparities in the juvenile justice system. Youth of color are treated much more harshly than white youth in the justice system, even when charged with similar offenses. Youth of color are much more likely to be arrested, formally processed, detained in juvenile detention centers, incarcerated in youth prisons, and transferred to adult court than white youth. And it's not because youth of color commit more crime than white youth. Results from self-report surveys indicate otherwise. And new research now shows that while youth incarceration rates are decreasing, racial and ethnic disparities are on the rise. Today, we have a unique opportunity to reform the juvenile justice system because there's now a rich body of research on adolescent development and on what works to reduce juvenile delinquency. Public opinion polling shows that the public strongly supports juvenile justice reforms, and in the last decade, states have undertaken reforms. Nearly half the states have enacted reforms to reduce the automatic prosecution of youth in adult court, increase the age of criminal responsibility, and remove youth from adult jails and prisons. Utah and Maryland are among these states. Another group of states have enacted reforms to close youth prisons and reallocate resources to community-based alternatives to incarceration. These states include Texas, Ohio, California, New York, Alabama, and the District of Columbia. To build on these state reforms and prevent tragedies such as Kalief Browder's death, Congress could take action. First, accelerate state reforms by supporting states in shifting their resources from incarceration to community-based alternatives. Second, reauthorize and strengthen the Juvenile Justice and Delinquency Prevention Act. Third, support states in increasing the age of criminal court responsibility to age 18. Fourth, provide adequate resources for states to enact these reforms. And finally, engage directly impacted youth and their families in these discussions and in reforms. Thank you for your time and consideration.
Thank you. Mr. Tolman, you're now recognized for 5 minutes.
Thank you, Chairman Chaffetz, Ranking Member Cummings, and members of the committee. I am the former United States Attorney for the District of Utah, a position I held for nearly 4 years. As U.S. Attorney, I made it a priority to protect children, aggressively prosecute fraud, to preserve American Indian heritage, and to stem the abuse of illicit and prescription drugs. Prior to my service as U.S. Attorney, I was an Assistant U.S. Attorney, a line prosecutor in the federal system. I personally prosecuted hundreds of felonies. While I prosecuted mostly violent felonies, I also participated in prosecution of white-collar criminals, drug traffickers, illegal immigrants, and others. Indeed, in nearly a decade with the Department of Justice, I was responsible for the prosecution of individuals currently serving long prison sentences, some as long as 35 years in federal prison. I am here today because my experience reveals the need for federal criminal justice reforms that are not only meaningful, but that are based on proven reforms carried out in states across this country. These reforms are the result of thoughtful analysis of deficiencies in the administration of justice in the federal system. I am not alone in my support of these reforms. Former federal prosecutors and other government officials have signed policy statements, including former U.S. attorneys, judges, and former government law enforcement officials that support H.R. 759, the Recidivism Risk Reduction Act, which is before the House Judiciary Committee, and the Corrections Act in the Senate. Many of us who signed this statement are noted conservatives who were some of the most aggressive appointees in pursuing crime. Because of our backgrounds as former prosecutors, judges, and other law enforcement officials whose service for this country is focused on law and order, we have come to realize the criminal justice system must be reformed. There are two meaningful ways the justice system needs to be reformed to begin addressing the issues facing us today. First, to address a back-end fix that efficiently uses incarceration resources. Accordingly, I speak strongly in favor of H.R. 759 and S. 467, the Corrections Act. Both bills enjoy broad bipartisan support. Though some of the bills differ, the broad prescriptions found in both parallel and would begin addressing the issues of overcrowding in our federal prison systems immediately. These bills would better prepare low risk of recidivism inmates back into society, would help ensure the first-time offenders do not become repeat offenders. It is my opinion these bills are the most likely of any proposal to date to not only have such an impact, but to have an immediate impact. Recidivism in our criminal system is endemic. Most of the low-level, nonviolent offenders in our prison are not rehabilitated during their incarceration and too often return to prison. Another result is a prison budget that is consuming an ever-increasing percentage of the DOJ's budget. The overall cost of detaining federal offenders consumes nearly 30% of the DOJ budget. During my tenure as U.S. Attorney, many U.S. Attorneys' offices, I observed, were unable to hire additional prosecutors and were forced to abandon law enforcement obligations and long-time partnerships. That the number one complaint I heard from chiefs of police and sheriffs across my state was the absence and loss of federal partnerships on important programs they were working. In 2009, California, using a 3-judge panel, issued rulings that required tens of thousands of inmates to be released with no thought to rehabilitation or risk of reduction of recidivism. Rather than addressing its prison issues through careful and deliberate means, California spent years in court battling to reduce its prison population. Time, effort, money spent on these court battles would have undoubtedly been better spent reducing its prison population in safe, deliberate manner as other states have done. In contrast, several states, many of which are among the most conservative in the nation, have moved in recent years to implement similar legislation found in H.R. 759 and S. 467. States including Texas, Rhode Island, Ohio, Georgia, North and South Carolina, and Utah. In Texas, similar legislation led to the closure of 3 prisons and a savings of nearly $3 billion, all while reducing the risk of recidivism from 26% to 4% in one case study. Finally, the other change that is much needed reform is addressing the expansion of the Federal Criminal Code and federal regulations and the associated disappearance of mens rea. Some estimates put the number of federal regulations carrying criminal penalties over 300,000. It is simply beyond the capacity of any person or even any organization to keep abreast of the number of regulations. With the explosion of the regulatory state, the mens rea requirement is all the more important. Throwing people in prison who not only lack the intent traditionally required for incarceration, but who often pose very little risk to society and have a similarly low risk of recidivism only serves to exacerbate the challenges of an already expensive and crowded system. As a former law enforcement official, I know firsthand that our current system is far too costly, does not focus limited resources on the most crucial areas of enforcement, and does not prepare inmates, especially low-level offenders, to return to life outside the prison. These problems can be addressed by legislation currently in Congress. I urge members of Congress to act quickly before the problem becomes an emergency that must be addressed by drastic, reactionary, emergency measures instead of deliberate, careful measures designed to protect the public. Thank you.
Thank you all for your testimonies. We'll now transition to the point where we ask some questions, and we're going to first recognize the gentleman from Michigan, Mr. Wahlberg, for 5 minutes.
Thank you, Mr. Chairman, and thank you as well for these hearings. As a former vice chair of a corrections committee in Michigan's legislature, and during a time when I saw Michigan go from, if I recollect, 17 prisons to 36 prisons, rapid expansion, with no resultant success in dealing with crime in the state of Michigan, and efforts on my part at the time to speak to the need for alternatives to incarceration. And in fact, being a parent of a junior higher son who was brutally beaten along with his friend by 3 teenagers on a bike path. Fortunately, my son didn't lose his eye. But going to the courtroom and my wife and I offering to the judge an alternative to incarceration, namely working on our farm, scraping and painting a barn alongside of their victim, my son, and myself in July in Michigan, and subsequently experiencing the reality of what it means to commit a crime and see the victim as human, and to experience my wife's good home cooking alongside, I believe would have had a better impact upon those 3 young men than ultimately the judge rejecting that and sentencing them to incarceration in a juvenile facility. And if memory serves me correct as well, 2 of those 3 offenders went on to offend again. Now, I don't know whether our alternative would have had a better impact. I bet it would have, but I'll never know because it wasn't allowed. So I appreciate your testimony. We have to go to what works, but also what's reasonable and what we should understand that makes common sense. I'd love to ask more questions along that line, but I do want to go to Mr. Levin and also Mr. Malcolm, since, Mr. Levin, you brought up the issue of the FAIR Act earlier this year. Senator Paul and I introduced H.R. 540, the FAIR Act, to address many of the abuses that occur within the federal civil asset forfeiture process, designed to be a good tool. We understand that. But it hasn't worked the way it should. It's become a tool for abuse as well, at least my contention. So I'd like to ask you, Mr. Levin, to expand on what you started at the final point of your testimony. What do you believe needs to be done at the federal level to reform this process of civil asset forfeiture? And how does forfeiture reform fit the larger criminal justice reform effort? And Mr. Malcolm, I'd like you to respond as well.
The mic, if you can hit the button thing.
Oh, thank you very much, Congressman Wahlberg, and thank you for bringing that story about what happened in Michigan to the forefront here. Really appreciate your commitment to this issue. The FAIR Act is, I think, a great proposal to address some of the abuses with civil asset forfeiture. And just so people understand, there's criminal forfeiture, but civil asset forfeiture is where people's money and property is taken before they've been convicted of any offense. And in many instances, they're never actually charged. And there have been a few cases recently where federal authorities, sometimes working with state authorities, just found a guy on a train, an Amtrak train, going from Chicago to Los Angeles, and took the thousands of dollars he happened to have that he was going to use to make a music video, and he's never been charged with anything. They didn't find any drugs. There was no, and he's still waiting to get the money back many, many months later. So the FAIR Act would abolish equitable sharing, which is a mechanism that states and the federal government collaborate. And the way, unfortunately, the good news is a number of states have put certain restrictions on civil asset forfeiture. New Mexico actually got rid of it this year. But by using the equitable sharing doctrine, the states are able to circumvent their own restrictions and get a piece of whatever funds are seized, and then the feds get part of it. So it's created kind of a mechanism for abuse and getting around state law restrictions. The FAIR Act would also raise the burden from preponderance of the evidence to clear and convincing evidence before property can be kept by the feds. And then it also reforms the structuring law, which is in some instances tripped up innocent people who just made a series of deposits from their business for a legitimate reason. It reinvigorates the innocent owner defense. We've seen cases where a hotel owner faced losing their property because there was prostitution or there was drug activities there, but they didn't know about it. So this would make sure that there actually is a knowledge requirement. And then also matching the severity of seizure with a crime, which recognizes that just because you're smoking pot on your front porch, you shouldn't lose your home. And making sure people, indigent people who confront civil asset forfeiture can have a lawyer provided if they can't afford an attorney. The only circumstance where they're entitled to that now is if it's their home that's being seized. And finally, the FAIR Act also has reporting so that we can know in how many cases there was actually a conviction. The bottom line is, as you said, Congressman Wahlberg, this is a well-intentioned policy that was designed to take money and assets from like drug cartels before they could hide them and so forth. And so that is a legitimate goal, but it has gone too far, and we do need to have reasonable restrictions to ensure that innocent people aren't tripped up. And so finally, I think it does relate to many of these other issues in the sense that, first of all, like the growth in regulatory crimes, it's part and parcel of the over-federalism, over-federalization of crime, over-criminalization. And just as we've seen the growth of the federal government in so many areas, this is just another area. And it does, I think, also implicate just our constitutional rights and the need to protect those. So thank you.
Thank the gentleman. And I would ask the panelists, members only have 5 minutes, so we got to be careful and a little tighter on those. And
Mr. Chairman, I may have talked too long myself.
yeah, no, that was no. Go ahead. Go ahead.
I'll be brief since Mr. Levin answered much of them. Civil asset forfeiture, of course, did have good intentions to deprive bad guys of their ill-gotten gains in facilitating property, and we have at Heritage have commented on your proposal and on the FAIR Act. I would also note that one of the things that's unfair about the forfeiture process is a lot of it never takes place in front of a judge, but is handled administratively with rather Byzantine and harshly enforced rules that often end up hurting property owners. Raising the standards, reforming innocent owner defense, I concur with what Mr. Levin has said. Perhaps the biggest thing is that, look, law enforcement agencies need to be adequately funded to do the vital work that they do. However, civil asset forfeiture provides too great a profit incentive, a direct profit incentive for them that can end up warping priorities. It also allows them to basically fund their own budgets without the oversight that comes and transparency that comes from the appropriations process. And so while I fully believe that law enforcement ought to be adequately, indeed generously funded, having that direct incentive through civil asset forfeiture has had a warping perspective.
Thank you.
Thank you. Thank the gentleman. Now recognize the gentleman from Pennsylvania, Mr. Cartwright, for 5 minutes.
Thank you, Mr. Chairman. Mr. Chairman, on February 25, 2013, about a month and a half after I was first sworn into this office, Correctional Officer Eric Williams of Nanticoke, Pennsylvania, was working at the U.S. Penitentiary, high-risk penitentiary in Canaan, Pennsylvania. He was excited about the job. 34-year-old young man. His mom and dad were proud of him. He was devoted to his friends and his family. That day at Canaan, he was working alone, watching 130 angry and dangerous prisoners, when Jesse Kanui attacked him savagely and violently. I won't go into the details because the Williams family are listening to this. Eric Williams died 2 years after starting at Canaan, and it was because of overcrowding and understaffing. Prisons across the United States are operating at levels far beyond capacity, putting both guards and inmates in danger. In a 2014 memorandum, the Department of Justice Inspector General found, quote, "Prison overcrowding presents the most significant threat to the safety and security of BOP staff and inmates," unquote. The same OIG report found that prisons remain significantly overcrowded and face a number of safety and security issues. While there is a downward trend in the federal prison population, as of June 2014, federal prisons were operating at a 33% overcapacity. This is dangerous. The BOP's long-range capacity plan projects prison overcrowding to be at 38% overcapacity by fiscal year 2018, higher than it is today. Now, Mr. Malcolm, what do we have to do to ensure that the federal prison population does not creep up to 38% overcapacity?
Well, I would note, Congressman, that for the first time this past year, there was a small downtick in the federal inmate population. Of course, overcapacity is not unique to the federal system. Indeed, there are probably greater overcapacity issues in the states. I believe that some of the proposals that we've talked about today, both front-end reform, limiting the amount of time that certain offenders are sentenced to, and also spending some money that we currently spend building new prisons and spend money to house people would be better spent providing the kinds of programs that would make it less likely that people would recidivate once they are released. And that way you can help reduce the overcrowding problem that exists and use those prison cells for the people who pose the greatest threat to public safety.
All right, thank you. And Mr. Tolman, as a former U.S. attorney, you know, Eric Williams died that night. You believe that one of the solutions to the problem of overcrowding and understaffing is to take a look at overcriminalization by examining the proliferation of federal criminal laws. Is that correct? Can you explain how it would help?
There's two things that would help immediately. One, those 130 that were in that facility that he was supervising, of those, there is a significant portion that are low risk of recidivism that are there because of the expansion of the Federal Criminal Code that could be in pre-release custody, could be sent to alternative than release custody, such as home confinement for $4,000 a year as opposed to $30,000 a year. That would make an immediate budget impact. And then the proliferation of the federal code has put people in those beds that create the inability of a single individual to observe 130, and that tragedy occurred because of that.
All right, I want to follow up with you, Mr. Tolman. I come from northeastern Pennsylvania, the Middle District of Pennsylvania, where U.S. District Judge Richard P. Conaboy still sits. In 94 through 98, he sat as the chair of the U.S. Sentencing Commission, and he often talked to us, the lawyers practicing before him, about the hamstringing nature of the federal sentencing guidelines and how it took discretion away from federal judges. Do you agree that it makes sense to repose wide discretion in the sentencing capabilities of federal judges?
I do agree. Federal judges should have discretion. Not every case is the same. A one-size-fit-all is not going to work when it comes to sentencing people to long prison sentences.
Thank you. I yield back.
Thank the gentleman. Now recognize the gentleman from Wisconsin, Mr. Grothman, for 5 minutes.
I'm very sympathetic to this topic, but I think some of the testimony is a little bit kind of you're all on the same page, and I want you to respond to some people might think the other thing. Our homicide rate in this country has dropped, I believe, by over half in the last 30 years. And I think arguably one could say that, you know, if the homicide rate had been what it was 30 years ago, another maybe 8,000 or 9,000 people would be murdered every year, which is not nothing. Given that the homicide rate has dropped like a stone at the same time the prison population is going up, I would have thought the increase in the prison population ought to get at least a little bit of credit for that. I'll ask, I don't know who I can pick out of the mix here. Well, it's John Malcolm. How about you out of the mix? Don't you think that the increase in, you know, raising the penalties has a little bit to do with all the lives that have been saved as the murder rate drops? Would you give it a little bit of the credit?
Yes, absolutely. I said in both my oral testimony, Congressman, and in my written testimony that, for instance, well-respected criminologists like University of Chicago Stephen Levitt says that increased incarceration is responsible for probably 25% of the reductions in violent crime. University of Texas at Austin's William Spellman puts it at 35%. Those are not insignificant numbers. However, that still leaves a very, very large percentage that where the reduction is responsible for other factors. I would also note, although times can change, Mr. Levin noted that according to Pew Charitable Trust, the 10 states that reduced incarceration levels the most over the past 5 years experienced larger drops in crime, 13%, compared to the 10 states that increased incarceration the most, which was only an 8% reduction in crime. There are anomalies, of course. All I'm saying is that while incarceration is indeed necessary and indeed important, it may not be the only, it is certainly not the only, and may not even be the best way of reducing violent crime.
Okay. I don't never know that you have cause and effect mixed up there, only on the grounds that one would think if crime goes up, your incarceration should go up, because as crime goes up, you'd be putting more people in prison. But next question I have for Mr. Ring, who recently got out of prison. I'm not sure how much it costs to house an individual prisoner in the federal prison system, but I know in the state of Wisconsin it's over $30,000 a year. Do you have any suggestions, whether you saw any waste or that sort of thing, in how we could cut the cost there, or maybe by cutting the cost, free up money for more job training programs and this sort of thing? Were there any observations of waste that you saw?
There were, and this is something that has always struck me, that in the prison system, most people who find waste, fraud, and abuse in every area of government somehow think the Bureau of Prisons is run so efficiently, and it's not. There was a lot of waste and abuse, and there was some outright fraud, some of which I know the Inspector General is looking at, and that should occur. Otherwise, I think the way that you can cut costs is for the lowest level of the nonviolent offenders. I was at a prison camp, so these were supposedly the best of the best. And people who started at a medium or a secure facility moved their way to the camp. But there were people at the camp who were 70 years old or were disabled in some way. You could have cut costs by letting some of these people get to home confinement or to halfway houses. But I agree with what everyone has said. That money has to be put back into the prisons to go after, to sort of treat the people who do need help. But there's plenty of waste there and overspending, and I think that has to be addressed. And I'm glad this committee is looking at it.
Okay. In general, I hate mandatory minimums. Nevertheless, in my district, and I assume it's not unique around the country, there's been a shocking increase in heroin deaths. Number of deaths just beyond belief. And despite the huge increase in deaths, the judges, some judges, continue to treat it as no big deal. And I was thinking, I'm not sure how many of these are federal crimes, of introducing a bill making sale of heroin a mandatory minimum. I was wondering if you have any alternative as to how to deal with the explosion of heroin overdoses we're seeing in this country.
What are you looking for?
Well, I was going to, it's kind of one of those game shows you see on TV, whoever bangs the buzzer first. I don't know.
The gentleman-
Mr. Levin.
The gentleman's time is almost expired, so answer as quickly as possible here.
Well, certainly for those who have an addiction, the great news is there's more and more treatments that are very effective, non-narcotic injections that people can take that block the receptors in the brain. Obviously, people that are dealing, especially large amounts of heroin, are already subject to lengthy federal sentences. I did want to also address your issue on the murder rate to say in New York City, the role of policing is incredible. What was done under Giuliani, the murder rate in New York City fell by over 80%. It did not fall nearly as much in Chicago and other large cities. So I think that shows you that some excellent policing practices, such as broken windows policing, data, CompStat, and having police in the right place at the right time, you can actually prevent a lot of crimes.
I thank the gentleman. The gentleman's time has expired, and now recognize the gentlelady who represents my hometown in Illinois. Ms. Kelly.
Thank you, Mr. Chair, and thank you to the witnesses. Our criminal justice system has different effects on unique populations, as you have raised. The Sentencing Project published a report this year examining the ways people of color are disproportionately affected by the criminal justice system. And, Mr. Chairman, I would like to enter this report into the record.
Without objection.
That report explains, and I quote, "Once arrested, people of color are also likely to be charged more harshly than whites. Once charged, they are more likely to be convicted, and once convicted, they are more likely to face stiff sentences, all after accounting for relevant legal differences such as crime severity and criminal history." Ms. Ryan, can you describe some of the racial disparities you've seen in the juvenile justice system?
Thank you, Congresswoman. There are disparities at every step in the process. So young people of color are more likely to be arrested, more likely to be formally processed instead of getting diversion, more likely to be prosecuted, much more likely to be incarcerated, and much more likely to be transferred to adult criminal court. And this is well documented. The Federal Juvenile Justice and Delinquency Prevention Act has required all states to collect data on this, and we see this in almost every single state.
Also, if my son was here, he would say much more likely to just be stopped in general.
Absolutely.
According to testimony the American Civil Liberties Union submitted to the Inter-American Commission on Human Rights in 2014, sentences imposed on black males in the U.S. federal system are 20% longer than those imposed on white males convicted of similar crimes. That testimony also highlighted that nationwide, about 77% of juvenile offenders serving life without parole sentences are black and Latino. Ms. Ryan, how are these disparities reflective of those we see in the system overall?
These disparities are very reflective of what we see. I mean, I visit facilities all the time, and you see young people of color in these facilities, and what we see in terms of the disparities of kids being in adult criminal court, that's where the highest level of disparities are, at the point at which kids are transferred to adult court or prosecuted in adult criminal court, and certainly they're subjected to life without parole and other sanctions that adults face in those circumstances.
Mr. Levin, I see you shaking your head. Did you want to add anything?
Oh, no, I certainly would agree that the data certainly shows that there are disparities. And, you know, I think one of the ways we often think about it is particularly in the area of drugs, that, and this goes back to what I was saying about policing, I think it's very important to have the police in the neighborhoods where the most crime is, but we need a different type of policing. And so one of the challenges is, of course, if a youth or other person has drugs on them, they are more likely to get caught if they're in an area where there's more police. Yet we need the police in those areas that have high violent crime, which are in many cases areas that have large minority populations. So the challenge then is to change the type of policing that we're doing. And we have people like David Kennedy with the National Network for Safe Communities. We're doing call-ins that have Operation Ceasefire in Cincinnati, High Point, North Carolina. These have had great impact by working with ministers, grandmothers, bringing the community together, getting people out of gangs, giving them positive opportunities. And once, you know, someone is, for example, in New York City now, if they do find marijuana on someone, they're typically given they go to a desk, they get a citation, they're brought to the nearest police office, it's a desk appearance, they don't go to jail. So there's better ways to deal with it, and that can help reduce some of the disparities, handling things in a reasonable manner, particularly when they're very low-level offenses.
Mr. Ring, your organization, Families Against Mandatory Minimums, has called for policymakers to further reduce the disparities in sentencing between crack and powder cocaine, and it also called for existing reductions to be made retroactive. Why might it be important to further reduce the disparity in sentencing and to have that disparity reduction apply retroactively to people who were incarcerated prior to the change?
Quite simply, Congress, when it passed the Fair Sentencing Act and made the change in the crack law to lower the disparity between crack and powder cocaine, admitted it goofed. You had members who were around then saying, we didn't know what we were doing. We just pulled numbers out of the air, and we passed this disparity. And mind you, the Reagan administration asked for 20-to-1 disparity, and it was the Congress that moved it to 100-to-1. So there was sort of a pox on everybody's house there. But so Congress passed the law, made the change, but it didn't make it retroactive. So now you have people serving decades for decades-long sentences that Congress admits were a mistake. And so until you make it retroactive, I know the President's trying to do some of this piecemeal through commutations, but Congress really should act and get all of those people fairer sentences, because it's the height of injustice for them to serve those when they know anybody sentenced today is going to get a much lower sentence.
My time is up. My colleague is running a tight ship.
I thank the gentlelady, and I recognize now the gentleman from North Carolina, Mr. Meadows.
Thank you, Mr. Chairman. Ms. Ryan, you were indicating that people of color, I guess, are incarcerated at a much higher rate. That's what your study shows?
There have been studies that have been done in all the states showing that young people of color at every stage in the process, so arrest, formally processing in the system instead of being diverted out of the system, detention, conviction, incarceration, and transfer to adult court.
So in your analysis, where would you say the problem is? Is it at the law enforcement side, the prosecuting side, or judicial side? I mean, obviously you're saying that the problem is everywhere, so are you indicating that it's all law enforcement, prosecutors, and the judges that are being biased this way?
Well, what we're seeing, the studies show that there's bias that's in the system by all of these stakeholders. And so law enforcement tend to over-police and process young people of color formally, whereas white youth are not processed in the same way. They have a different justice system. Simply put, we have two justice systems. We have one for white people who have means, and we have one for young people of color who do not.
All right, so your contention then is that from the judicial side of things, is that judges are making disproportionate sentencing based on their purview. Would that be your contention?
Yes.
All right, so Mr. Tallman, let me come to you then, because if what Ms. Ryan is saying is that judges have great latitude, and according to what you just shared with Mr. Cartwright, is that you think that judges should have greater latitude, would that not exacerbate the problem that Ms. Ryan has just?
Appreciate the question. Congressman, I would answer it a little bit differently than Ms. Ryan would. Judges, I don't believe that judges in this day and age are largely driven by a bias in their sentencing, but instead you see, as a result of minorities achieving higher sentences, can most often come as a result of they're arrested more often, their records look worse. When they get there, when they get before a judge, they've usually gone through several proceedings that they may not otherwise have gone through, and then judges feel that they are tied. And in the federal system,
But they're not tied. You were just saying that they should have discretion, and I guess what I'm saying is, you know, I'm here. I love my law enforcement officers. I love my U.S. attorneys, and I'm perplexed because what some of them say is that we need to prosecute more, and we need to arrest more, and that they arrest people and they get out of jail free and they go another way. So I'm very perplexed, Mr. Tallman, because if we're going to give our judges more discretion, would that not give the probability of sentencing that was not uniform or fair?
I don't believe so.
All right, well, okay, so I assumed that you would go that way. So let me take you to a U.S. attorney situation in my district where they were charged with felonies. They pleaded them down to misdemeanors where they went before a magistrate judge, and then ended up, I've got a constituent who's going to jail for 23 months for hunting with a spotlight of which nothing was shot, and a hunting license that had expired for 24 hours. And he's going to jail for 23 months, and that was the discretion of a federal judge. So how can we say that more latitude with our judges would promote fairer sentences?
First of all, I don't think judges feel that they have discretion now. The sentencing guidelines, while not mandatory, are certainly still pervasively controlling what the judges do. In those instances where an individual has an offense, there are very distinct recommendations that come as a result of the sentencing guidelines.
Well, those were maximum, in this particular case, a maximum of 6 months, but they stacked misdemeanors so that he went to jail for a longer period than what you would think a normal misdemeanor would have. Do you think that's fair?
I don't know the case. I don't, first blush, I do not believe that would be a fair sentence. And it is the point that we are trying to emphasize, that the federal system is filled with more of those than they are Al Capones. And because of that, they're taking bed space that is required for those that are more serious. Now, the mandatory minimums have added to that. The emphasis on guideline ranges that are out of sync with what should be the punishment are creating that. And so I guess I agree with you and say that it will take a lot more time with true discretion and statutes that don't promote over-punishment before judges start to sentence more properly tied to what the seriousness of the offense is.
All right. I thank the chairman. I yield back.
Thank the gentleman. Now recognize the gentlewoman from Michigan, Ms. Lawrence, for 5 minutes.
Thank you. This is a discussion that's near and dear to my heart. I am a representative. I represent Detroit, and I also have some of the most wealthiest communities, not only in Michigan, but in the country. I just want to give some statistics. It's estimated that 2.7 million children under the age of 18 have a parent in prison or jail. That means 1 in 28 children in the United States has a mother or father or both in a lockup. Recent statistics shows that the United States holds 25% of the world's prison population, while we're only 5% of the world's population or people. Most inmates are parents of children 18 years of age, of children under 18 years of age. 2/3 of incarcerated parents, 2/3 are nonviolent offenders, often locked up for minor drug-related charges. They make up the majority of the parents who are in prison, and they and their children are the ones the criminal justice reform would most affect. The lack of parental contact and engagement during imprisonment hurts those children. It has been proven psychologically and socially. So I have 2 questions. First to Ms. Ryan. What is the impact, according to the studies that you've looked at, to the educational and social development of children growing up with a parent in prison?
I can't speak to all the studies, but a vast majority of them have shown that those young people are further behind in school than their classmates, and that there is an increased likelihood that those young people who have a parent in prison could end up in the criminal justice system as a result.
My ranking member yesterday in his opening comments referred to 3 generations serving time in prison. It's a statistic that I think our criminal justice system own some responsibility. Mr. Ring, you personally experienced this as a parent. I would like to hear your comments. And what can be done, if you could speak in a positive way, what do you think we can do to help the relationship between children and their parents during incarceration? And what are we doing right, and what should we stop doing?
Well, there's a couple of things. It's the hardest part of being in prison, clearly for everyone. And I am thankful that I had a shorter sentence relative to most. I saw people in the visiting room after months passed where you could see the relationship sort of falling apart. The kids weren't running to the parents anymore. And it's really hard when you leave that visiting room to go back onto the compound and your kids are losing their relationship with you. So it's very hard. I think the prisons aren't as cognizant of that as they should be. They pay lip service to it, but there's things like the 500-mile rule, which is you're supposed to be placed in a facility that's within 500 miles, but that's as the cock crows rule. It doesn't mean driving miles. So we had people from Rhode Island who are at Cumberland, Maryland. He almost never got to see their kids. Other things, like when I got there and I was really devastated to not have my daughters with me, I asked if we could sort of put together a fatherhood caucus because they had AA and NA, and I said, can we get a fatherhood support group so that the older guys could tell the newer guys how to stay in touch, how to space out your phone minutes, how to do that sort of thing. And we only had one therapist, and so she didn't even respond to that inquiry. So I think there are things that can be done, and I think as part of the programming, that should be part of it, because in some cases you have strong relationships that wither. In other cases you don't have strong relationships, but it's a great time to reinforce the people who are there. This should be your responsibility when you go out.
I agree with you. There is a responsibility in our criminal justice system to recognize the impact on those who are not incarcerated, the families. And if we truly want to break the chain and reduce the amount of people that we imprison, along with all the other reforms, this must be a critical part of it, and I yield back my time. Thank you, sir.
Thank you. Now recognize the gentleman from Oklahoma, Mr. Russell, for 5 minutes.
Well, I appreciate not only all of the fantastic information that's put forth here, but the scope of the problem and the fact that in a bipartisan nature we recognize that this is a national problem, regardless of politics or party. I want to address an area that I've not heard addressed much. Senator Booker in his testimony yesterday had mentioned upwards of 97%, I believe, of all adjudication of justice is done by plea. And I don't know the accuracy of this, and I don't have the data, but it brings out a major point. A person receives a charge. He gets publicity. Consequently, his employer fires him over the publicity. Then they have an inability to make bail because they don't have work, and then they can't obtain the best counsel because they can't afford it. The counsel that they do obtain then, in a deal with the prosecutor, is suggested to make the plea or roll the dice with the jury on an exponentially higher outcome of sentence. Faced with this duress, what we potentially see, and I would argue actually see, is the locking up of innocent people. How do we address that? Because we've not seen or heard anything along that line, and I welcome input from anyone on that issue.
I'll volunteer very quickly that the promulgation of disproportionate penalties and some mandatory minimums that are so extreme that you have that very scenario you described is driving that, and yet if you were to make punishment more commensurate and not punish an individual for going to trial to test the evidence against them, I think you would have a system that is intrinsically more fair. And that's part of the reform that has to happen on the front end. But for those that are in that system, that are the 97% that did it, we better have immediate back-end reform right now, or else they will continue to serve those very long, disproportionate sentences.
Congressman, my colleague, Mr. Tallman, during his testimony talked about mens rea reform and the importance for adequate mens rea. I think that's also a part of this. There are a fair number of crimes, particularly regulatory crimes, but also statutory crimes, where in order to convict somebody, you do not have to prove that there was any knowledge or intent to violate the law, or even that somebody engaged in something that is intrinsically morally blameworthy. And the fact that federal prosecutors have that pressure and can say, look, I don't have to prove whether you knew about the law, intended to violate the law. I just have to prove that you did the act that resulted in the crime, even if it was a mistake or a complete accident. Therefore, you're facing a very heavy penalty unless you decide to plea bargain. That's also part of the answer to this.
Yeah, it's an excellent point that you make, that you ask about, and there is data showing people that stay in jail pre-trial before their trial end up with longer sentences and are more likely to go to prison. And so some states like Colorado and New Jersey have adopted bail reform measures to ensure that people who are low risk can get out pre-trial, even if they can't afford a bail bond, through pre-trial supervision and a personal bond. It's kind of like being on probation, so they're held accountable to make sure they appear. But just because they don't have resources doesn't mean they're not able to get out. And then also strengthening, of course, indigent counsel and ensuring that there's quality representation. We have a pilot program in Texas going on, kind of like school choice, where clients can choose their own counsel from a list of qualified attorneys.
I would just say somebody was prosecuted. The leader of this conspiracy that I was a part of was sentenced to 4 years, 4.5 years. And I came later in that. I had been cooperating for a couple of years. When the government came to me, they basically said, if you cooperate, implicate these people, you'll see what you'll get, which is no time. If you don't, the range I was looking at was 19 to 25 years of prison. And I had real law and order, salt of the earth people, friends who believed in my innocence as I did, which is why I went to trial, say, you just got to take the deal. You have to take it for your kids. I said, you don't think I'm guilty? They said, it doesn't matter. You can't do that. And you see that a lot. And I don't know how anyone who thinks that, that there aren't innocent people in jail don't believe that people take those deals. You see the statistics when the Innocence Project exonerates people with DNA in these rape cases. Half of those people pled guilty. So you know it happens. And it's a problem, and it's a problem because there's not enough discretion for judges to counterbalance. I was lucky that my offense did not carry a mandatory minimum. That would have been tougher. At least I knew I was going to have a judge who was going to hear the evidence. But it's more proof to why you need to have more balance in the system.
And thank you, Mr. Chairman. I yield back my time.
Thank you. We'll now recognize the gentleman from Virginia, Mr. Conley, for 5 minutes.
Thank you. And I want to thank you, Mr. Chairman, and especially you, Mr. Cummings, for these remarkable hearings. Yesterday and today, profoundly thought-provoking, something that hasn't had the kind of scrutiny it needs. The American system of justice, from soup to nuts, is in many places broken. And the word justice is in all lower cases. You just mentioned one, Mr. Ring, and I know my friend from Oklahoma brought it up yesterday with our two governors. Plea bargaining was supposed to be an efficiency. It has now become a tool that incarcerates people who are innocent, not all. Innocent and guilt are irrelevant sometimes to the process. That isn't justice. That's a perversion of justice. And you're quite right. People then have to weigh the gamble. Take the lesser of two evils, even though I'm innocent. Because the risk of going to trial and losing is too great. And the fact that prosecutors who may believe you're innocent nonetheless pursue that is a perversion of justice, and shame on them. Sometimes prosecutors get into the habit, I know, Mr. Tolman, you might recognize this, where what's important is a scalp on the wall, irrespective, again, of innocence or guilt. I'm gambling I can win this one. That's all that matters. That's the ethic. It's not about whether, well, what about the innocence of the person in front of you? Not everybody, of course not. But it happens all too often. And there were so many other things. But I want to ask you about two in particular. One has to do, your story, Ms. Ryan, solitary confinement for a youth. It seems to me that ought to be a practice normally that's very infrequent. And only with manifest behavior that is otherwise completely uncontrollable, danger to himself, herself, or others, and for limited periods of time. You described a tragic story of a young man who ultimately committed suicide, presumably not unrelated to his very unjust incarceration in terms of what he was being charged with, and it was a failure of the criminal justice system to get around to him that he had to languish in Rikers. How often ought solitary confinement be a tool in the prison setting for young people?
That's a great question. In Khalif Browder's case, he was charged with a crime, so he was pending trial,
Right.
And he was being abused by guards. They placed him in solitary confinement, so this is pending trial. We know that it's used often in the adult system for children in the form of protecting these children, and it is profoundly harmful to those young people, to their development. It's also used, unfortunately, in the juvenile justice system, and there are all kinds of euphemisms for solitary confinement. I had an argument with the Department of Corrections head here in the district one time because he called it a timeout, and I called it, 5 days in the hole is solitary confinement. Unfortunately, we don't know how often it is used, and that's something that Congress could fix by requiring states to provide data on
But
this.
the fact that we would subject a young person to solitary confinement for his or her own protection, of course, tells us a lot about the prison environment, that we would need to do that, understanding there are consequences that flow from doing that, the isolation and so forth. I'm running out of time, so I want to ask one more question, ask you, Mr. Tolman. Washington Post just did an interesting series on the power of parole boards, not trained, often political appointees, capricious decision-making. God only knows whether, there's nothing systematic and analytical about how we look at your case and arrive at a just decision. Your experience, and if you'd comment on that in the remaining 27 seconds.
Thank you. There is no parole in the federal system, but there is a need for that role if it was administered fairly, which is why the bill that has been introduced, H.R. 759, would actually take that out of the discretionary. What it would do is it would say, we're going to assess the risk of recidivism and reassess the inmate as they go and let them earn time into home confinement. So you take the parole board out of that and some of those problems that came from it.
I would note to the gentleman from Virginia, Mr. Conley, that please have a look at the Cedric Richmond has a piece of legislation that I co-sponsored. We introduced it that deals with the solitary confinement, requires a study and reporting so that we have these types of statistics, because you just worry there's these horror stories out there, we'd never hear about them, and this piece of legislation is part of a package that we're encouraging to.
I thank the Chair. I most certainly will. And I also just want to say, one hopeful thing about this process, you and the ranking member have gotten underway here, but in terms of the broader conversation too, that's hopeful to me, is actually on the right, on the left, Republicans and Democrats, we're all actually beginning to re-examine what we thought was taken care of from top to bottom. And I think that's a really healthy sign. So hopefully we will continue to look at issues like solitary confinement, but also the broader issues that challenge American justice. And again, I thank you, Mr. Chaffetz, and you, Mr. Cummings, for leading us down this path.
Thank you. But now I recognize the gentleman from Georgia, Mr. Heiss, for 5 minutes.
Thank you, Mr. Chairman. And I likewise just want to give a sincere thank you, Mr. Chairman, to you and to our witnesses for this tremendously important hearing. And I typically don't do this, but I do want to take just a moment to share a little of a personal experience with all of this because it really hits home just from the last couple of months with me. I'm from Georgia, And of course, Georgia has been known in the past as being extremely tough on crime. And frankly, that toughness over the years has not worked. It's cost the state tons of money, and our jails have been filled to the brim. And under the leadership of our current governor, Governor Deal, he has taken this issue on personally, actually campaigned on this issue as well. And as a result, Georgia has been, as you know, has been mentioned here in the last couple of days, on the forefront of implementing some critical, momentous front-end and back-end reforms to our criminal justice system. And we are seeing incredible results. One of the programs, or at least part of it, involves some of these nonviolent offenders, particularly who have drug problems, to be able to participate in court-supervised rehabilitation programs that involve a great deal of accountability. It's an 18-month to 2-year program. There's, as I mentioned, a lot of accountability. These people get jobs, they do community service, they have regular drug tests, they're involved in evidence evidence-based treatment programs that involve both the faith-based community as well as others. And there's consequences if any of this stuff lapse, but even then the consequences are not just designed for arbitrary punishment, but they're designed to get these people back on their feet so that they can live a drug-free life. And just May, I had the distinct privilege of speaking at one of the graduation ceremonies. I've heard of this program in Georgia for several years, but I had the hands-on experience of speaking at one of these graduation ceremonies, and I tell you, I was moved to the core. In fact, there was not a dry eye in the place as one of these individuals after the other gave testimony of what their life was and what it has become and what these programs have meant. And then family members and friends also testified as well. And, you know, at the end of this program, these people have literally 2 years under their belt of drug-free. They've been in the workforce, all these kinds of things, and it was just incredibly moving. One of the statistics that came up, I believe it was yesterday, with the recidivism issue is I think most of our prisons see people, once they're released, back in prison within 2 years. I mentioned results in Georgia. We are seeing through many of these drug court type things across the nation, for that matter, the recidivism rate is 25%. In Georgia, it's even less. In Barrow County, where I spoke a couple of months ago, it's significantly lower than even the 25%. And so I guess all of this is just, I'm so grateful that we're having this hearing. And again, just send sincere thanks to each of you for being on the front line of what you're trying to do, and for Chairman, your leadership in bringing this forward. Mr. Levin, let me just ask you, and I'm sure you have dealt with this. I apologize for coming in late myself, but what alternatives to prison do you see? I'm sure you're looking at Georgia and Texas, some of these other places, but to reduce recidivism, get these people's lives straightened out.
Well, you hit the nail on the head, Congressman. Drug courts, the Hawaii Hope Court, which is a similar model, but it's more targeted just towards weekend jail for those who fail the drug test, and then even actually some of those who can't quit through that and ultimately go into the drug court where they get more significant treatment. Mental health courts, veterans courts, then other alternatives including electronic monitoring, various mental health treatment programs, both inpatient and outpatient for people with that problem. And so house arrest has been mentioned, so there's a whole host of alternatives, and I think one of the things we ought to look at is enabling the federal system through perhaps, the federal system could compensate the state, but to be able to place some individuals, whether it's in a halfway house or one of these other programs that is actually run by a state or a nonprofit, rather than, because it's very hard for the federal government, particularly in places where there may not be that many federal offenders, to try to reinvent the wheel of everything states are doing. So why not have a way for the federal government to partner with states and nonprofits and use some of the same programs?
Well, excellent. Again, I'm out of time, but again, I hope this committee continues to look at cost-effective ways of turning lives around as opposed to just punishment. And I thank you, Chairman.
Thank you. Georgia has done some very significant things. We tried very hard to get the governor of Georgia to come join us, but through scheduling on both ends, we were unable to do it. But Georgia has really helped lead the way, and they should be thanked for that. Now recognize the gentlewoman from Illinois, Ms. Duckworth, for 5 minutes.
Thank you, Mr. Chairman. I'm so glad that we're having this much needed debate in our country, and especially in this committee on the dire need for reform in our criminal justice system. I really want to go back to the discussion on drug offenses and mandatory minimum sentencings. Mr. Chairman, I have in front of me a statement offered to this committee, to this hearing from Human Rights Watch that echoes many of these concerns. I'd like to have this statement entered into the record.
Without objection, so ordered.
Thank you. Regarding prosecution and mandatory minimums, Human Rights Watch explains that, and I quote, mandatory drug sentencing laws have given prosecutors too much power. They are able to strong-arm drug defendants by offering them a choice, significantly shorter prison terms if they plead guilty and excessively severe sentences if they go to trial. Coerced pleas and disproportionately harsh sentences should not be part of the federal criminal justice system. And my colleague from Oklahoma began this discussion on that already, and I'd like to further this sort of power relationship. Mr. Ring, you said that prosecutors in your case initially asked for a 20 to 27-year sentence. That seems incredibly excessive for a nonviolence offense. You know, I have to wonder, you came into the system as someone you know, fairly highly educated, a lot of experience, not easily intimidated, I would think. And I just wonder, you know, what your experience was in terms of facing that potential mandatory minimum, and then thinking about the folks that you saw when you were in prison. And if you think about someone whose entire life experience begins with stop and frisk and unnecessary police stops and a law enforcement system, while we have great law enforcement officers, but a system that is skewed, especially towards minorities, what that does to that power relationship between the prosecutor and the defendant.
Thank you. Let me just say, I try to always make clear that my case is definitely unique. I mean, I'm a congressional staffer, I'm a lawyer, I worked for sentencing reform, I knew a lot of these issues, and so it was certainly a different situation. The reason I usually raise it is just because I want to show how much power the prosecutors have without mandatory minimums, because they were able to threaten that sentence because the guidelines are still so high too, and the guidelines are usually driven by the mandatories. So when you lifted the drug mandatory minimums, the white-collar folks on the commission said, we got to lift these up too to make them to have parity. So the guidelines are very high too. The people I saw in prison looked nothing like me. I mean, I hope it's clear, and I don't think everyone knows, that there's no club fed. I mean, I was definitely a minority in the prison. Most people are brown and black, and that's another problem in terms of getting programming to such a disparate group of people. But these folks faced mandatory minimums. They didn't know anything. They know nothing about sentencing law. It's such the divorce between what members or politicians think that is going to deter a criminal, as if they are listening to, you know, that if you pass a 5-year mandatory minimum, the next year they're going to, oh, I'm not going to do that anymore because they just stiffen these penalties. There's no idea. Most of these guys made stupid mistakes without any idea of what the punishment was. They just didn't think they were going to get caught. So you can make the severity off the charts. You can do life sentence for jaywalking. It's not going to stop it. So it is a problem. These people don't know. There's a lot of bad lawyering, and some of these people had really terrible representation. And so the people who can't afford it, and I don't know anybody who can't afford to go to trial today, it's a huge problem. And so I think that's why you see so many lower-level people who have no resources just cave to the system.
All right. Thank you. Mr. Tolman, as a defense, with your experience as a defense attorney, have you seen defendants discouraged from exercising their right to trial? And I want you to speak to this power relationship, because it seems like the way this is set up, it just gives excessive power to prosecutors, and that you have a defendant, you know, who's from a community where they see all their buddies or their friends who get stop and frisk and minor drug offenses end up in jail for these long periods of time. I would think that that power relationship is just excessive.
It is extreme power. We could, as a federal prosecutor, I could control what the sentence would ultimately be. because of our ability to wield the particular statutes we wanted, because of the guideline ranges, because of enhancements we could apply, and we controlled the ability to also go down from those guideline ranges. It influenced me as a defense attorney so that my practice currently, I tell many of my clients, we need to be successful prior to you being charged, or we need to be cooperating in a way, or we need to show the government that we are going to be very different than just an individual that they prosecute and goes to trial. I cannot, in good conscience, advise any of my clients at this point to go to trial because the resources and the evidence and the penalties present incredible obstacles to exercising your constitutional rights.
Thank you. I'm out of time, Mr. Chairman.
Thank you. Now recognize the gentleman from California, Mr. Liu, for 5 minutes.
Thank you. Thank you, Chairman Chaffetz and Ranking Member Cummings, for these important hearings on criminal justice reform. My first question is to the entire panel. Do any of you believe it's wise to spend even $1 of precious taxpayer resources to arrest, prosecute, and lock people up for marijuana crimes, especially when multiple states have legalized marijuana? Okay, I take that as a no. Thank you. I'd like to focus on recidivism.
Yeah, I mean, obviously there's people that, you know, if you're dealing huge amounts of marijuana as part of a cartel or something, but I think it's certainly been encouraging to see, even in states, and we can debate whether, you know, it should be legalized or not, but certainly even in states that haven't legalized, they're diverting people. In Houston now, they're bringing them to the police station. They can do 8 hours of drug education or community service. So bringing small marijuana offenders to jail is a, I think, wasteful use of resources.
Thank you.
Yeah, if I could also quickly jump in, I think that very, very few small marijuana possessors are prosecuted federally. I am not generally, I do think that there are federal laws that are way overreaching, perhaps in this area too, but I'm not a big fan of unequal enforcement of federal laws. If you're going to have them, then I believe that they should be equally enforced.
Thank you. I'd like to talk about recidivism. Ms. Atomni had testified that within 3 years of release, nearly 67.8% of prisoners are rearrested, and then within 5 years, 76.6% are rearrested. I dealt with this when I was in the California State Legislature. We had a massive prison overcrowding problem, and when you look at the facts, it wasn't that California had longer prison sentences. We were about the middle of most states. It's because we had a massive recidivism rate, and we were locking people up for nonviolent offenses in prison. So I'd like to turn to Mr. Ring, and I listened and read your testimony, and it's a stunning indictment of a lack of rehabilitation programs at the Bureau of Prisons. And I think you testified that you saw little to no rehabilitation in prison, that most inmates skipped classes and would just sign their names to attendance lists during the week, so the administration thought that they went, and that the most glaring deficiency was the lack of any cognitive behavior therapy or anger management counseling. But then your conclusion to me is sort of odd, because you go from that and you conclude that I think the only way Congress can improve public safety while reducing costs is to reform sentencing laws, especially mandatory minimum sentences, which I support you on, but I would have thought you would have said the most important thing we could do is reduce recidivism, and that means increasing rehabilitation programs, making sure that people don't recidivate, because if you don't do that, what will happen is, and you reduce sentencing laws, instead of having a person serve 2 longer sentences, they're going to serve 4 shorter ones. I don't think you do very much to reduce prison overcrowding or reduce incarceration. So I'm just sort of curious how you go from your first part of your testimony to that conclusion, rather than say we should focus on recidivism reduction.
Okay, that's a fair question. I'd always hear the term warehouse, that prisoners were warehoused in federal prisons or prison, and I didn't know what that meant until we got there. You're just sitting there, and there's nothing happening, so you're just looking at the clock and you're waiting to go home. And there's no programming, anything like that, so you find ways to make yourself busy. And as I said, if you had any skills, they atrophy and you don't gain any new ones. So to me, being there itself is a complete waste, and letting people get back into their lives before they lose touch. People would say, what's an app? They're going to come out and have no idea what the world is like when they get out. So to me, the thing that you can do immediately is right-size some of these sentences. But it'd be a mistake to think I don't think you have to do both. You absolutely, while they are there, forever long they are going to be there, have programming. And one thing I think the problem is that if we just said, let's just increase programming across the board in federal prisons, state prisons, that's a lot of money. We're going to have to own up to the fact that there's going to take a lot of resources to have the kind of programming that you want. And I think you got to couple that by getting some savings from sentencing reform.
Thank you. When I was in the California State Legislature, and this ties into your point about having programs that deal with anger management and behavior therapy, I got an increase in funding to arts and corrections programs. And arts and corrections programs have been shown to reduce recidivism. It actually, in fact, teaches anger management and behavior therapy in a different sort of way. There were nonprofits such as the Actors Gang, run by Tim Robbins and others, that were doing it for free for quite a while, and then we were able to scale them up. It seems like we should do this in our federal prisons, in addition to getting rid of mandatory minimum sentences. But my belief is we need to really reduce the recidivism rate if we actually want to reduce the overall prison population. And with that, I yield back.
Thank the gentleman. Now recognize the gentlewoman from the District of Columbia, Ms. Norton, for 5 minutes.
Thank you very much, Mr. Chairman. I want to thank you and the ranking member for focusing on what is really a rising bipartisan issue in the Congress. I'm pleased to say, Mr. Lujan asked a question I was obligated to ask. I take it none of you think that it makes much sense and do not find prosecutors thinking it's much sense to prosecute people for for possession of low amounts of marijuana. Is that the case?
I gave the answer that I gave before. I think that you may make a very compelling argument that this shouldn't be a violation of federal law. But as a general matter, I believe the federal laws, if they exist, should be enforced evenly, and that means.
Well, so let me take you to the next answer. The harm that is done is not that there's any prosecutor in his right mind has so little crime that he goes after low-level marijuana possessors. The harm that is done is the arrest record. And what we find is throughout the United States, overwhelmingly virtually the only residents here in the District of Columbia, 90%, of those who get arrest records for possession of small amounts of marijuana are people of color. For a young man, especially of color, this is a bar for the rest of his life. Leave aside that it's marijuana. Leave aside that it's not a conviction. What would you do up front about arrest records for low-level offenders like this who are possessing for their own habit? By the way, this is a college town. Half of those, the marijuana rate, smoking rate, is the same for people of color and white people. We got 5 or 6 universities in here. I don't remember seeing anybody get arrested.
Well, and that's, yeah, and I think citation certainly is a way to give someone in Florida, they are doing juvenile and adult civil citation. So giving someone a citation certainly can address it rather than arrest them. And then the other issue
and that citation, I take it, wouldn't be on his record so that the employer would say, well, you got a drug arrest, that's enough for me?
Provided probably that they complete whatever, they show up in court, they do whatever they're supposed to address the citation. The other thing is enabling people to get a record sealed if they do have a record, and we've passed legislation in Texas to allow nondisclosure, so that way you can say on an employment application you haven't been convicted because you obtained an order of nondisclosure.
Thank you. Senator Booker was here and testified about the REDEEM Act. It's very important, juvenile, expungent, automatic. People, as it were, earn their way out of jail simply by paying their time. Then they face the problem of additional earnings. Have you thought about a way to earn your way to expungement or sealing of your record? Because for all we're doing, black boxes and the rest of it, when you see choices between people who have no record and people who do whatever the merit of the people who have something of a record, that's a black mark. Is there a way, have you thought about a way for a person to actually earn expungement of that record?
Sure, and I want to distinguish in Texas, expunction is reserved generally if you're innocent, if you're acquitted, or the case is dismissed, but non-disclosure is a bit different because the records aren't destroyed, but law enforcement can still see them, prosecutors, certain licensing agencies for things like doctors, things that are very sensitive. But if you have a non-disclosure, which you can get even if you were guilty, that means you have your record sealed after a certain number of years of living crime-free. You can say when you apply for jobs that you haven't been convicted, likewise when you apply to rent an apartment. And we've also, by the way, passed legislation in Texas to say employers and landlords can't be sued for hiring or renting to ex-offenders.
Doesn't something of that kind serve as a kind of incentive not to commit more crimes? I mean, has it been shown in any way? Is there any evidence that could then be used in other states?
Absolutely. Minnesota and Indiana passed good sealing laws in the last couple of years, and I will also tell you the evidence shows if someone's been living crime-free for 5 or 6 years in the community, they're no more likely to commit an offense than someone who never had a criminal record. So there's no value to these old records being publicly accessible.
I can't say enough about incentives for people not to recidivate. Thank you very much, Mr. Chairman.
Thank the gentlewoman. We'll now recognize the gentleman from Missouri, Mr. Clay, for 5 minutes.
Thank you, Mr. Chairman, and let me thank the witnesses for appearing today. The work that you do in the area of criminal justice reform is of vital importance, and I'm eager to learn from your expertise. On Friday, it was announced that President Obama, as part of his plan to reform the criminal justice system, will be the first sitting president in history to visit a federal prison, which will take place tomorrow. This unprecedented action prompted me to wonder whether those of us in Congress should consider doing the same. And as a bit of background, in my days in the Missouri State Legislature, I was the chairman of our prisons committee, so I've visited numerous state prisons, have not visited a federal prison, and I would like to throw that question out to anyone on the panel on what you think the redeeming benefits would be of a member of Congress going to visit federal prison. We'll start with Ms. Ryan.
I think that would be great because I think that you would be highlighting some of these issues in a very personal way. I would encourage you to go to the BOP facility in Lewisburg, Pennsylvania. That is one of the most abusive and heinous places in the Bureau of Prisons. Young people who are incarcerated there in their late teens and early 20s are subjected to very harsh and punitive actions by guards and placed in solitary confinement. So if you're going to pick one place, I hope you'll start there.
How about the family members that go to visit, and how are they treated?
I'm not as familiar with how the family members are treated, but the stories that we get through letters and calls usually come from the family members, so they often will share information. But what they tell us is that if they show up and they're wearing the wrong thing, or they've got, they came at, a couple minutes late, they're not allowed in, and that's really difficult. And I think the point that Kevin made about families being very, very far from where inmates are held is also another huge issue.
Can I add?
Okay. Yes.
I just got back from touring prisons in Germany, and one of the interesting things we saw is probation officers come into the prison a month or two in advance to help that inmate start looking for a job and identify housing even before they start supervising them after they're released, which I actually do supervise them. And I'll also tell you, our chair of the Senate Criminal Justice Committee in Texas, John Whitmire, he not only visits prisons, but he shows up unannounced.
Just to build on that, please go and please show up unannounced. If you say you're coming, the whole dog and pony show will get put on for you. When we're on the inside, all of a sudden we get new shower curtains that the mold is gone, and everybody's working real hard and looking busy, and it's really it's Potemkin Village. There's no reason to go if you're going to go that way, but I urge you to go.
If I might add, when I was a congressional staffer, I accompanied senators to Guantanamo Bay, in which they were going to reveal to us their methods of interrogation. It was far different than what we would later learn occurred in those interrogations. And so I echo the unannounced visits, but I would say, more importantly, require reporting. Get into the actual data that shows you what is going on, and dig through the data that's going on in those prisons.
And what do you think would surprise a member of Congress most if we made an unannounced visit to a prison? Mr. Ring?
I would just say the lack of sort of concern. I think that people are pretty much, and again, I was in a camp, but we only had a couple guards. I mean, we could walk out the fence if we wanted to. I mean, there was a level of trust because we were considered the least risk. But just how little there is going on in terms of programming, activity, like sort of, I don't know, beneficial activity, anything along those lines. Just, I think people say, well, it's good, it's boring. That doesn't sound bad. I'd like to be bored. But it's sort of a mind-wasting boredom. And if there's nothing productive to do with your time, I think people turn even more antisocial than they were when they get there, which is part of the problem.
There's no real effort toward rehabilitation then in our federal system.
That was my experience, and I think it's a product not only of, part of it is a product of budget. I mean, I don't know if they know the programs. I don't see a lot of evaluation of the effectiveness of the programs they are running. As Mr. Holman said, get reporting on this stuff. If we're going to fund more programs, see what works and doesn't work, and be willing to go a different direction.
I think I'm my time.
Thank the gentleman. People on my Facebook page think I should probably be there a little more often for a longer period of time. Yeah. So, yeah, maybe we should just announce that we're coming, and you don't need to actually show up and get some new curtains. So that was a good line of questioning. All right, we'll go to the gentlewoman from New Mexico, Ms. Lujan Grisham, for 5 minutes.
Thank you, Mr. Chairman, for this important hearing, and I want to thank the panel. And I really want to, again, as we're focusing on recidivism, so that we are looking at what populations ought to be incarcerated and for what reasons, and what we do about that in this country as we look at broad-based criminal justice reform. I hope this is a stepping-off place to do that. I think it's really important to recognize that our criminal justice system is a place where, in my opinion, we are warehousing a mental health population. Given today in this country, we've got almost 8.5 million Americans who have both a mental health diagnosed disorder and a substance abuse issue. These co-occurring issues, we know, unfortunately, go hand in hand, given the lack of resources for this population. And we also know that as a result of that substance abuse issue, that we are not only holding and then treating those behavioral health issues, the fact that we don't deal with them on the front end, we're dealing with them in jails, we don't deal with them on the back end either. So if once you serve your time and you're out, we aren't doing anything to resolve those drug addiction and the issues associated with having a mental illness. And until this country does something about behavioral health issues, I fear that we can make lots of adjustments to the criminal justice system, but we are still going to have it as a de facto environment for institutional care for this population. Given that, and given that we know that the resources, we could make lots of discussions, we should have lots of discussions, that in New Mexico we pay higher than the national average. I think it's $30,000 a year for an inmate. We pay $34,000, and yet we pay $7,300 annually on public education for students. So I think about my state, where we're having so many issues. If we were reversing those investments, and when I was a Bernalillo County Commissioner, we would have loved to reinvest those resources, because we just don't have them in the criminal justice system. You started to explore in looking at incentives in the conversation earlier in the hearing. What else are states doing to try to address the behavioral health issues. For example, New Mexico is just now working on Medicaid enrollment while you are serving time. So as you come out, we've got a insurance program to make sure that you're getting access. Now, that's not in and of itself garnering productive access, but it's a step in the right direction. Are there other measures that we can look at that would be best practices to begin to deal with, on the front end and the back end, behavioral health issues for this population?
Congresswoman, it's a very important point. I mean, ever since we had the deinstitutionalization movement in the 60s and 70s, a lot of people who used to be treated involuntarily are now in the streets in our communities, and there are inadequate amounts of money that are spent on outpatient behavioral and mental health services for those people, and a number of them, of course, end up committing crimes, and that poses a real problem for the safety and security of those who are in prison, since dealing with people who have mental and behavioral issues is a very different type of problem than the your standard inmate that doesn't have these problems. States can address these through things like mental health courts, veterans courts, since our returning veterans suffer from emotional disorders that are unique to the experiences that they have had, that try to get them the help on the front end to keep
And
them
I don't
out.
mean to interrupt you. You're on the right track. I totally agree. But these are also states, particularly with the mental health courts, that have a behavioral health system, including mandated outpatient treatment programs, which New York launched early, and other states have struggled to get the sort of civil rights aspect of that correct. But if you have also best practices that marry those behavioral health services with those systems, I'd be really interested in the states that are doing the best at that, since 80% of this population gets back in the criminal justice system and clear that they're not getting what they need once they've been released.
Well, my colleague, Mr. Levin, could better address what each state is doing. I would say that states are not uniform and that there are, different states have different environments and perhaps should adapt the solutions that work best for them. So, for instance, been a reference made to the Hawaii HOPE program, which is tied to methamphetamine, while other similar programs in the Dakotas, for instance, the 24/7 program, address alcohol problems, which are the large problems in those states. Each state has to adapt their programs to their conditions, and they should study those results rigorously and share them with other states who may be able to replicate those results.
Thank you. My time has expired, but Mr. Chairman, perhaps we could get a list of those and think about whether there's a federal, so that you can create some uniformity and really create the right kind of environment for reform.
Thank the gentlewoman. We'll now recognize the gentleman from California, Mr. Desaulniers, for 5 minutes.
Thank you, Mr. Chairman. I first want to thank you and the ranking member. I frequently say that as a freshman, we have a lot of surreal moments. This is one of those surreal moments in this committee that having served a lot of time in politics in California and been in the state legislature and having chaired the budget subcommittee when we were told by the federal courts that we needed to remove 45,000 of our inmates in the California Departments of Correction, and I was given the assignment only because no one else in the legislature was dumb enough to do it. So I remember during that period visiting state prisons, and I remember standing outside of San Quentin, which is next to my congressional district, and the warden is now retired that was there then, but he was a tough old ranger, had been the warden at San Quentin twice, long time at Pelican Bay, and we were standing outside on the San Francisco Bay, and he said, you know, if you told most of your constituents that what we're doing is making them less safe by doing what we do when we incarcerate these individuals, it would change the political dynamic quite a bit. And he said this in the tone of somebody who had spent 35 years at the Department of Corrections, starting as a line officer. So my question, maybe Mr. Levine first and Mr. Malcolm, is we spent a lot of time in those hearings with Washington State, who had the Institute for Public Policy, which was an MOU between their legislature and the administration, and Cleveland State University. And they started on evidence-based practices 20 years ago in Washington State about we're going to depoliticize a lot of this. The legislature's still going to make the decision, so they're not off the hook. But we're going to give them enough evidence-based research that gives the public the confidence that these are the right investments to make, so that you're not driven by being afraid of being Willie Hortoned in a primary or general election. So how do we do that at the federal level? Or maybe we're right on the cusp of doing that, that we rely enough on evidence-based research that we do what's the best investment from a policy standpoint to make sure that the public is in fact safe at the lowest possible cost. Mr. Levine?
Well, that's a great question, and we've used the work of the Washington State Institute for Public Policy, their cost-benefit analysis and matrix of programs that reduce recidivism, and you can kind of look at the other step in that is to match the right program with the right offender through risk and needs assessment. And obviously, at the federal level, you have things like the General Accounting Office that provide objective information. Maybe there's a way to expand their role in evaluating. I think having an independent outside the Federal Bureau of Prisons to evaluate whether programs are effective or not in reducing recidivism, which programs we may need more of. And you have to do it in an objective manner because you have to look at who's going into the program, what is their risk level. You don't want to just have an incentive to put the lowest risk people on a program to show results. You actually want programs to really intervene with those who would otherwise be at the highest risk of recidivism. And I just your anecdote about the San Quentin warden really rang a bell with me, and as well as the things that you said, Kevin, because, you know, I was talking to some people with the Prison Entrepreneurship Program where they go in with executives and help inmates develop business plans, but they said when some of these inmates come out, they first go to their first meal at a restaurant, they just stare at the menu, but they can't figure out what to order because they haven't had to make any choices this whole time they were in prison. And as I was in Germany, I saw, for example, they had communal kitchens. They would pick out ingredients and make some of their own meals. That's just one example of many where they did take on more responsibility, and they have in statute there that the prison should be as much as possible like general society, so these people are prepared to live when they return.
I would say, Congressman, that states and the federal government should obviously do everything they can to avoid what happened in California, being forced to release large numbers of prisoners through the Plata decision. Look, with respect to avoiding Willie Hortons, there are a lot of very brave governors in red state, blue states, and purple states that have touched the third rail of running the risk of being soft on crime. Governor Deal was referred to, but you could also refer to former Governor Perry and Governor Haley and, you know, the governors who appeared here yesterday to testify before you. And they are, you know, taking a methodical approach. I would say that bringing in best practices, that whatever it is that you do, it has to be measured, it has to be constantly reevaluated, and it must be statistically valid and scientifically sound, or else you are just putting a Band-Aid and making it seem as if you are doing something that will ultimately not result in reductions of recidivism and will not enhance public safety.
Yeah, I'll just say we have a very visible case right now, unfortunate murder on the waterfront in San Francisco, and it's become so politicized. It would be nice to be able to have an organization, and this involves, because it involves immigration and federal authorities, that could go in and do a forensic, sort of like the chemical industry does, just do a forensic root cause of why did this happen, and what do we do to fix it? And I'm unaware of something in this field that would be able to do, for instance, in the case of Catherine Steiner, who was 32-year-old, unfortunately murdered by someone who was here illegally, and now it's cut off this storm of politics, around this great tragedy, as opposed to what did the immigration folks do that they should have done correctly? What did the Federal Bureau of Prisons do that they should have done correctly? And what do sanctuary cities have to do with this in a less dispassionate, more forensic, evidence-based research so we could fix it? Because you have to wonder how many of those situations, how many people have been deported 5 times, got back in the country, and there but for the grace of God, we would have had another tragedy like that. With that, I would yield back.
Thank the gentleman. Mr. Cummings and I have a few more questions, and then we'll be at the halfway point. We're getting near the end here. So, now recognize Mr. Cummings, the ranking member, for 5 minutes.
Thank you very much. Your testimony has been extremely helpful. I think one of the things that I'm most concerned about, and I just want to get your opinions on this. I've often said that there are transformative moments in our lives when you know that all the stars are aligned, you see the problem clearly, and you know that if you don't correct it at that moment, it only gets worse. What do you all see? I mean, you see Congress and the Senate seem to be coming together, And do you see, I mean, would you agree with me that if we can't get it done now, it's going to be kind of hard to get it done, Mr. Tolman?
I wholeheartedly agree. I'm worried about that because there are a lot of dynamics and politics does get in the way, but you're correct, I believe, that we're now seeing the problem. We're looking back and we're seeing a culture of punishment that we had hoped would root out criminal trends, but instead what that culture of punishment has resulted in is problems that are far more difficult to take care of. And now is the time, or else we will be, similar to California, having missed our legislative opportunities to fix it.
Anybody else?
Well, I mean, I think you're absolutely right. We've seen kind of, you described, and we've described all these different states where legislators have come together. Some of these states have passed reforms unanimously. In other states, it's been a few votes short of unanimous. And so it is fairly rare. And obviously, we've seen so many bills in Congress with kind of unlikely co-sponsors. So I believe that people who say that nothing can get done in Washington, I think we have a great chance to prove them wrong this year.
Ms. Ryan, you talked about Lewisburg. I remember visiting Lewisburg to see an inmate years ago, many years ago. It's interesting that that prison could earn such a reputation, but apparently a lot has changed. It seems to me if I were running an institution and it had, and I know, and I'm sure the Bureau of Prisons is looking in on us now. I hope so anyway. And I had a prison like that has that kind of rep. I mean, what does it take to reverse that other than, the spot visits or, what are the questions that one asks? What can we do to correct that kind of situation? We are elected by the people to make, and this committee is to make sure that government operates properly. And it would be, I think, legislative malpractice if we did not do what was appropriate, assuming that we know what to do. And so what advice would you give us?
I think there's a number of things that you can do, and I think it's great that this is an oversight committee because that's really what's needed for the Federal Bureau of Prisons is much more vociferous oversight. And the point of having surprise inspections is really true. I think if they know you're coming, they're going to put on a show. And the other piece that you have to be concerned about is retaliation against anyone who's incarcerated there. So you can't just talk to a couple people here and there, and you can't do it in the presence of guards. You have to talk to everybody. You have to stay for a couple days. And doing that takes a lot of time and energy. But I would encourage you to establish an independent oversight board of the Bureau of Prisons that has this kind of function, and that I would encourage you to have directly affected family members as members of that board, because you will learn a lot more from the families who have loved ones in these institutions. And then I think ultimately we have to stop investing in things that don't work. I mean, all of this talk about investment in what works is great, but we continue to invest in things that don't work, like trying kids in adult court, putting people in institutions where they're subjected to inhumane confinement. We know solitary confinement is harsh and punitive. We should stop doing that. So those would be the things I would start with.
Can I also just add one thing that came up earlier? With regard to people pleading to things that they didn't actually do, I think the open file policy, which we've adopted in Texas, it's also in the SAFE Act, is very important. That allows the defense to see exculpatory evidence, to have transparency. Now, obviously, there's things that need to be redacted, dealing with victims, Homeland Security, but in general, there ought to be, and the reason this came about in Texas, it's called the Michael Morton Act, because this man served 26 years in prison. He didn't kill his wife. He never committed any crime. And he helped then pass this legislation.
Mr. Ring, I can't help but think about what you said about family. I just father of two beautiful daughters myself. I know it has to be difficult. And you admit that you had it easier than most people. People in my neighborhood, they go to hard time. They have hard time. You know, it's painful. In a city, and I was thinking about marijuana. I got people in my neighborhood serving 2, 3, 4 years for marijuana, and then they turn on the television, and they're buying it in Colorado. What kind of justice system is that? You know, and going back to, I think you said it, folks aren't, you know, they're not looking at the penalties and all that, but they do know one thing. When they turn on the television, they see people sitting in a bar with dollar bills buying marijuana, and they got cousins sitting in jail. They don't understand that. And I'm just wondering, how do we deal with the family thing? I mean, because we heard a lot of testimony about people who have adults who have children, millions of them, that are finding it very difficult. So what do you have to say about that? And what's your organization doing to deal with that? I mean, you know, I've often said that, Mr. Ring, out of our pain, quite often comes our passion to do our purpose. Pain, passion, purpose. And I'm sure you saw a lot. You felt a lot of pain. You just got a sample of the pain that a lot of other people are going through. And I'm not trying to minimize it. Don't get me wrong. But can you help me with that?
Yeah, I was always cognizant of how good I had it. I had a shorter sentence. You learn not to talk about your sentence if you had a shorter one. I lived with bunkmates who had 15 years, 10 years. I remember one time a guy saying to me, you know, he was getting short, and he started losing his mind a little bit because he was getting nervous, and we had a talk one time. Actually, I was going through a bad time, and he was counseling me, and he said, "You don't know my life." He said, "You're just dying to get back to your neighborhood and to your kids and your house and your job. They're all waiting for you." He goes, "I'm going to go back to my neighborhood, and all my old friends are going to want to get me back in the game because they were drug runners." And he was deathly afraid of that. He was one of those people you meet that was so institutionalized. I do think there was a big chunk of him that thought he was better off there because he had been there for 8 years. His wife was taking care of the kids. They were there without him. He almost knew that status quo worked, and he could live in prison. He was so scared about going out. That's a terrible situation if we come to that point where he thinks he's better off in jail. There's no policy, I think, that fixes that. I think you can do a better job of keeping people closer together and programs that work on parenting. But I think it's a cultural thing. I think we're very vengeful people. I think that even people who have minor convictions, when they go for a job application, people look at you funny. I know a lot of people who, again, it wasn't my experience, but didn't get jobs. If it's down to you and somebody else, you're tossed out. So I think it's bigger, broader, cultural. I think in the same way you've seen other movements normalize different sort of things in our country, what we did with smoking, what we did with gay rights, other things. With prisoners, there has to be a sense that you're coming back, we want you back, and we're going to welcome you in society in a way that makes you productive, because it's in our interest too. But that is not something you can legislate, I don't think.
You know, one of the things, it's amazing how after you're on earth for a while, you do so many things. And one of the things that I have different jobs, and one of the things, two things I did, was when I first came out of law school, I taught in a prison in the Maryland Penitentiary for 2 years, as a matter of fact. Just an ad hoc, just a little course on of all things criminal justice. And it's interesting that later on I hired some folk who had gotten out of prison, who I had taught. And I noticed something very interesting, that I think prison does something to people, because I think because they're told when to sit, when to go to the bathroom, whatever. Maybe not for you, but for people that have been there a long time, they have no concept of, some of them, no time, of responsibility, of a lot of things that, and I don't know that people know that prison does have, it's more than just locking up the body. It also, quite often, and you were alluding to that, affect the mind. I know people who have come out after many years, and they don't even want to come out of the house. They don't even want to come out of the house because they've become so conditioned. Would you, I mean, any of you all want to comment on that? I had a whole other line of questions, but I'm finished. But I do.
I had a conversation with a federal judge fairly recently that has sentenced some significant sentences, and he said to me in a moment of candor, you know what prosecutors have forgotten? And I said no, and he said, how long 2 years actually is? Because the sentences you seek as a prosecutor often, you think of 2 years as a minimal sentence and perhaps a failure in your case. You think of 8 and 10, and these numbers become almost badges of acceptance in the community that you're in as a prosecutor. And this judge said, you know, who's been on the bench a while, said, we've forgotten how long 2 years is.
Wow. Mr. Chairman, there's just one other thing. I don't know whether we got this in the record. The ACLU written testimony, American Civil Liberties Union, House of State, dated July 15th. I'd like to have that submitted.
Without exception, so ordered. You yield back?
Yeah, yield back.
This has been a very productive 2 days. We've had 3 good panels, good quality discussion. We've talked about a whole variety of topics. If there are additional materials, additional statements that you would like us to review that could inform us, we'd appreciate that. Everything from drug rehabilitation, I think the point made about the mental health issues and how we're not assessing those, not dealing with those, and so many of these people who have mental health problems are ending up in our system and dealing with law enforcement on a regular basis. Very interested in Texas and what they're doing with the sort of client choice. This could be nothing worse than know or feel you're innocent, or at least you want a good quality trial, and you get assigned a public defender who's not up to the case and doesn't seem to care about you. You ought to have some choice. I just believe in that type of principle. It's probably true in this instance as well. I'm intrigued by this oversight of the Bureau of Prisons, because we are only as good as the information we get, and we get spread very thin. The Inspector General, in this case, I think does a good job, but even they are spread thin on this issue. And one thing that I would like to be addressed, and if you can follow up with me on, is, and we haven't really talked about this, but there are victims' rights. You know, there are victims on a lot of these crimes. Not everybody in prison is innocent. There are a lot of people that have been harmed, and I think to complete the circle, to totally tackle this in a thoughtful way, I think we need to also address victims' rights. And if you have additional thoughts or perspectives on that, we haven't really heard that in the last 3 days, but that too, in the completeness, the fullness of the discussion and trying to get this right, we but get very few opportunities to address these things. I would encourage, I've been a participant, working hand in glove and across the aisle and in a bicameral way to get legislation passed, and then it won't be addressed for a long time. And so we have but one chance, and I want to get it right. Whether it's a series of bills or a bill, I do hope we come together and that we can push this. I think you've seen a broad bipartisan support, not just 1 or 2 people, very broad bipartisan support. We need to keep that momentum going. So we thank you all today for your expertise, what you've given to your country, your patriotism, and we thank you. This committee stands adjourned.